Good morning, members. The committee is resumed on the Outer Space and High Altitude Activities Amendment Bill. When we suspended last night, we were debating Part 1. Once again, the question is that Part 1 stand part.
Madam Chair.
The Honourable Rachel Brooking.
Thank you, Madam Chair, for that. So, as you noted, last night we were on Part 1 and near the start of Part 1, and the Minister had engaged with a range of questions, which was very helpful to us because, of course, we're in all stages urgency, and this is the only chance for us to ask questions and to get things on the Hansard as well, which I think is helpful. So one of the questions that she answered yesterday, I was asking if she could name some of the places that have this space infrastructure, and she confirmed that Space Ops, which is in Aotearoa, near Bluff, and also in Warkworth, that they would definitely be covered. But I didn't hear her say about the organisations that do both the launch at Mahia Rocket Lab, but also the horizontal launching at Tāwhaki, if they would be covered or not. So it would be just useful to know the answer to those two questions, those two places specifically, and if there's any longer list of the places that are already existing, not an exhaustive list, but if there are other places that would be captured by this, that's just helpful to know. Also confirming, I think she mentioned that universities and scientists would be covered, so they're not exempt. We were talking about that ham radio operators are exempt. So just to confirm that around new section 49A, which is clause 7. Then I'll go through a bit further. We've also, to the Minister and the Chair, a number of us have asked questions about the role of mana whenua in this. I don't think that was commented on. And if I go through now, I've got a couple of things I just want to touch on that the Minister might be able to answer quite quickly. So at clause 7, and new 49D, so maybe on page 8 of the bill, there's mention of a specified person or class of person, and I was wondering if the Minister has any... Oh, bless you. That was quite the interjection. So I hope the member is well. So the question there is just if there is any example of a specified person, so that's referred to at B1B. And just going through my bill. Another thing where it might be useful to have examples is at clause 21 and new 83B, which is the direction to stop providing electricity or internet services to the space infrastructure. If there are any examples of that sort of thing happening anywhere else in the world, where that idea to stop providing electricity or internet services came from, and if that covers everything or not. And then it would be also good, and other speakers might ask more specific questions on this, but we are amending the Principal Act, which obviously will say how regulations are made, but it would be useful for the Minister to discuss how the regulations will be made that are set out in clause 24, the new regulations, what sort of consultation there will be with people, given that this is all in urgency. Now, I also want to bring the Minister's attention to an amendment in my name, and that is to enable a post-enactment review, because this is going through all stages urgency, and we accept the Minister has said that it needs to go through urgency and that there is a real need for this legislation to be in place. So whilst we accept that, it would be useful to have a post-enactment review in case there are mistakes or there is somebody is going to be impacted in a way that we haven't thought of during our time here. So this amendment in my name suggests going to the Foreign Affairs, Defence and Trade Committee. However, I'm very happy for that if the Minister is interested in this amendment, very happy for that Select Committee to be the Security and Intelligence Committee, maybe, or the Regulations Review Committee might be another one. Then I've also said in this amendment that that Select Committee should report back to the House no later than November the 25th, 2025, Madam Chair.
The Honourable Rachel Brooke.
Thank you, Madam Chair. So again, that date is entirely arbitrary, and one that I picked based on Tuesdays, because this Act is going to come into effect on a Tuesday on the very happy for the Minister to suggest amendments to that and table other amendments, or for the Minister to do that. But the point of this is that committee would scrutinise the legislation that's already operative, so the timing issue isn't at issue, but properly look at the legislation and engage with those people who know about space infrastructure, and then report back. And then if the House agrees to those recommendations, then amendments suggested by that committee are treated as an amendment bill, with the bill proceeding without all of the stages that we would have in a normal amendment. So that is the suggestion. I'd be very keen to hear the Minister's views on that. And as I say, the timeframes and the select committees, or if there are any changes, we are very pleased to discuss those. But the point is, we're going through all stages urgency. We accept that there's a reason for all stages urgency, but there is no opportunity for us to have good engagement with people who know about the subject matter, and this would provide an opportunity for that to happen without inhibiting the bill from commencing. Thank you.
Madam Chair.
I call the Honourable Chris Pink.
Thank you very much, Madam Chair, and good morning to all members of the committee. A couple of interesting contributions already, one by the Honourable Rachel Brooking and one by another member. I didn't see who sneezed, but I hope she's recovering. Ladies and gentlemen, a number of issues, as best as I could judge, a number of issues have been raised, both reiterating comments and discussions from last night by the Honourable Member, and I have the benefit of some of the analysis that flowed from those questions asked last night and now this morning too. So please indulge me, members of the committee, if I run through those as best I'm able in terms of understanding the discussion that's taken place so far. The first is around the point about the coverage of the Act as compared with those different locations versus those that the members asked as to whether they'd be covered by the ambit of the regime. Up in Warkworth, which is an area within my patch, was referred to, as well as down south, where the member herself hails from. But in terms of vertical or horizontal launches, these would be covered, I understand, if they operate GBSI that's within the scope of the regime. So it's not, there's no attempt to exclude or include more explicitly than that. But I should point out, for the sake of completeness, that activities that are already covered by the Principal Act and are not being brought in or out of the regime by the amendment, can be understood to be captured or otherwise already in those terms. As for a specified person, that will be a person specified in regulation, and I'm sorry that sounds quite circular and possibly unhelpful at this point, except to say, of course, the regulation-making power, as the members referred to, will contain a certain amount of the necessary detail, and that will be able to be updated as time goes on, in the way that regulations are more readily updated, of course, than primary legislation. And so I point out that in terms of the members' thoughtful suggestion that a post-enactment review be mandated by the legislation, a certain amount of the detail will be under constant review by way of that regulatory process, including any regulatory review, but also there's a constant review with a small r that takes place, of course, in terms of the operation of any legislation. This being an Amendment Act, the amending provisions would be reviewed constantly for the effectiveness and also the extent to which they interact with other rights and responsibilities of New Zealanders particularly. and the Minister feels, and I in her place am happy of course to relay but also support the notion that we don't need to specify a mandated review mechanism, be it in front of the Security Intelligence Committee or indeed Foreign Affairs, Defence and Trade as per the original proposal. And in terms of turning off electricity as being a particular action that might be taken, the intent there, or the enabling of that action, is to prevent the remote operation of such infrastructure while a disposal order is carried out. So it buys a bit of time in that sense, pending the disposal, and that's where it's deemed to be necessary on national interest grounds. And just referring to the wording of the legislation, conditions imposed by the Minister are said to be those which may include without limitation, those that are specified in the Act. So is deliberately not excluding the range of conditions or actions that might be taken, noting of course that in this highly technical realm and with developing technology, it might well be the case that there are conditions or actions that might be necessary in the future that we're not able to contemplate now and would be inappropriate to calcify in primary legislation as compared with responding on an ongoing basis through enactment of regulation. As for urgency, of course the member is rightly diligent to note that we need to examine as carefully as we can within the context the bill, and of course the Committee of the Whole House stage is at least one way of doing that. But I think it's also worth reiterating a point that was probably made last night. In fact, I'm certain that it was, that this is an urgent proposition, and the attention of the House, including its committee today, is important to deal with the issue as expeditiously as possible so that we can have the benefit of these defensive measures in the case of those who would do harm to New Zealand and its national interest. I'll leave my contribution now. I see my 5 minutes is nearly up, but I will acknowledge the point made around consultation and say again there's nothing to preclude that on an ongoing basis in terms of the way that the Act is operating.
I call Tiano Tuiano.
Thank you, Madam Chair. Just to pick up on some of the answers that the Minister just gave us, I think the point with the post-enactment review is I think everybody around the House understood what the Minister was saying. A gap needed to be plugged, and there is broad acceptance of that around the House. I think the point is you have to actually be sure that the wheels are going to stay on the wagon. I guess the point is, are all the nuts and bolts actually screwed on properly? And so a post-enactment review would enable that to. Will enable us to actually have a more thorough kind of look at it to make sure that it does what it says that it does. Another question around the turning off the electricity part of it, I was wondering, well, what does that mean for people that are on solar? What does it mean if they're on battery? How will the regulator know that? They might think that actually, this GBSI is not doing what we said it was going to do, so we're going to turn off the electricity, and I think that's all going to be fine. But actually, there are a lot of different ways around it. So I guess it'd be good to understand practical ways of actually how the regulator would deal with that particular issue. I also have another question around the application. The application process, and so I guess the question is, if someone gets the permit to be able to run a GBSI, and it's a company, but then it on-sells that to somebody else, and then they on-sell it again, and then next thing you know, it's in the hands of a nefarious, possibly foreign actor that is counter to our national interest. How does that work? How does the oversight happen on that? Because often, as we know, there are different kinds of arrangements that can happen. So a question there around that possible scenario, which officials behind you might have already thought of, possibly already have, but I think it would be useful for the House to understand that particular perspective. And just coming back to the questions that have emerged about where exactly this applies, my hearing of it last night was a situation like Waihopai wouldn't apply because they've got the Defence Force exemption, but Mahia would apply because they don't have that exemption. But if I was wrong in terms of how I heard that, getting some clarification from the Minister about exactly what is being covered here, I think would be really important. So those are my questions.
Madam Chair.
I call Venetia Walters.
Thank you, Madam Chair. Just to speak, I do have some questions for the Minister, but I just wanted to start by speaking in favour of my colleague the Honourable Rachel Brooking's amendment. I think the response from the Minister was that there would be review of the relevant regulations, so there's not cause for concern in that regard. However, I do think that yesterday when the Minister spoke in the Chair, she spoke about the regulations coming into force after a year, and that she would be exercising powers in the meantime. And so there are aspects that aren't attached to the technical content of the regulations that, in my view, ought to be examined ordinarily by a select committee. In this case, we don't have that opportunity, and so in my view the proposal is a valid one because there are very unique powers, in my view, that are being exercised within the national security space, which otherwise wouldn't be examined. The other issue that potentially wouldn't be examined in the ordinary process of creating the regulations is something that is unique to the House itself, which is whether the substantive content of the regulations is best suited to primary legislation or to regulation. Certainly that happens through some PCO advice to the Attorney General, but my view is that that's a legislative function, and again ordinarily that would happen within select committee processes. So those two aspects in particular, it doesn't feel to me that there is post-leg scrutiny on them. So again, just speaking in favour of that amendment. Some other specific questions just resulting from the discussion yesterday. The protective security arrangements definition lists, not an exhaustive list, but things that the applicant, if you like, would need to include. There has been a lot of discussion about nefarious actors and third-party actors, and I did wonder whether there was consideration of being more explicit in that section, so speaking explicitly about corruption, explicitly about bribery, and what requirements, what investigations would need to be made of third-party actors. And then I'm also looking at section 6 amended, which is the exemptions section, which a few others have touched on. I was curious as to the meaning of 6(2)(b)(1). So that's the exemption for New Zealand Defence Force, but it's also an exemption for a person assisting or providing services to or working jointly with the New Zealand Defence Force. And I wonder whether the Minister could give us an understanding of the scope of that, whether that could include foreign actors who we act in partnership with as well, what the intended scope of that exclusion is. The other exclusion is 6(2)(b)(3), which lists an intelligence and security agency. My question there is whether the intention was for that to read New Zealand Intelligence and Security Agency. The reason I ask the question is because in number 4, just under it, it specifies the New Zealand Police. So just considering whether there's need for an amendment there or whether there's a definition that I haven't spotted which makes it clear that we're speaking here about the New Zealand Security and Intelligence Service. Thank you.
Madam Chair.
The Honourable Chris Pink.
Thank you very much, Madam Chair. I'm seeking to take a call to respond to the thoughtful questioning from both members who have contributed in the hope of sort of staying on top of the issues that have been raised. The wheels on wagon metaphor raised by Te Aotearoa, of course he's right to say that we need to identify if the wheels might fall off a regime, but of course there are ways of doing that other than by specifying in statute that a particular type of review must take place at a particular time. And to extend the metaphor, if the wheels are wobbly or the vehicle is otherwise not proceeding as it should in the right direction and in a smooth fashion, then of course it's incumbent upon the government of the day, and of course including the government agencies for which there is regulatory stewardship responsibility, to investigate that. And it seems to me that this is a matter that is sufficiently high stakes that the appropriate degree of scrutiny as to the ongoing operation of the regime would be considered and watched carefully, such that any such shortfalls or mechanical difficulties would be identified in a timely fashion. As for turning off electricity as a particular mechanism, I take the member's point that, of course, solar and other ways of operating electricity exist beyond the traditional way, but if not a switch to be flicked on or off, I assume that there are ways that power could be disabled in the way that's contemplated by the legislation in respect of GBSI, or ground-based space infrastructure. I was remiss in not having spelt that out earlier at least once, but the acronym from there on is probably and hopefully acceptable. As for clarification in terms of whether the likes of Mahia Peninsula activities are caught by the regime, I don't wish to be definitive in a way that would be unhelpful, where I seek to tender what would effectively be legal advice and be wrong, so I won't venture an opinion on that, except to again just reiterate the point that to the extent that activities and locations are already captured by the primary legislation is to be amended, then we're not necessarily displacing that by the addition of the measures in this amendment bill. As to the points made by Venushi Walters, I do take on board her point about regulations only being reviewable in that typical way, and also the time gap. So if I may say, that seems to me a worthwhile point to make. But nevertheless, of course it happens all the time that the House will make a determination on that which is appropriate for the subject of primary legislation as opposed to secondary or tertiary at the point that the legislation is made, and then a determination of the content to fit within the regulations is made after. And of course that's the nature of a regulation making power, as my fellow alumni of the Regulations Review Committee will appreciate. And so I'm not sure that I can take that point much further, except to acknowledge her having raised it. And of course there's always a tension between the detail that one includes in primary legislation versus the expansive ability to add over time, but also technical detail in regulations that of course may be amended in a much more timely and flexible manner later. As for third-party actors, I suspect it would be unhelpful to be more specific about the types of nefarious activity that we might want to include, even in the way that we might say that there might be other types contemplated. It's probably typical within the realm of national security that we wouldn't want to bind our hands in a way that we would find unhelpful, albeit, again, I acknowledge a tension between certainty and that going to the rule of law dictate ordinarily, of course, that the law must be knowable. So I'm hopeful that the measures in the bill would be applied in an appropriate and proportionate way. And I know that the Minister for Space would understand and take seriously those responsibilities, not least of all because she's the Attorney General and of course understands that balance of rights approach that's always appropriate and no less in such occasions as this. As for Section 6 exemptions, I don't myself yet know if those working with the NZDF might include non-New Zealand agencies or entities, and if I receive some advice on that in time to be helpful to the member, then I'll certainly look forward to relaying that.
The Honourable Phil Twyford.
Thank you, Madam Chair. I want to just direct attention to subpart 3A, the provisions 83A around disposal orders, 83B giving the Minister the opportunity to unplug the electricity system, 83C forfeiture orders. So these are, I think, by any measure, quite draconian provisions that give the Minister the power, if certain criteria are met, to order the disposal of private property and ultimately to put in place a forfeiture order. It's easy to imagine a scenario where that would result in very significant economic harm to the owner of that ground-based space infrastructure. And I wonder, given how keen this government is on enshrining the principle in law of compensation to the owners of assets that are affected by regulation, with the current passage through the legislative process of the Regulatory Standards Bill, the government's obviously very keen on that principle. And I wonder whether or not the Minister has considered the possibility of, let's say, the Russians operating a bit of ground-based space infrastructure that we deem to be a threat to the national interest, or they've somehow inveigled their way into some other private sector operator providing a service, and yet the data is ending up in the hands of the Russians, just for argument's sake. And the government chooses to close that down, causing significant loss either to the Russians or their erstwhile partners. Would the government consider compensation consistent with its adherence to the principle in the Regulatory Standards Bill? So I'd be keen to hear the Minister and the Chair's view on that, but also I wonder whether in fact the government has considered that there are embassies and diplomatic missions in New Zealand who operate ground-based space infrastructure. They operate satellite technology that I'm pretty certain would meet the definition of ground-based space infrastructure. And if a diplomatic mission is conducting the interception of signals and so on from its properties here in the capital, and it was deemed to be doing so contrary to the national interest, would those diplomatic missions be covered by this bill?
Thank you. Madam Chair.
The Honourable Chris Pink.
Thank you very much. I look forward to responding to those points made by Mr Twyford. To come back, however, first to the question that was posed by Ms Walters. There isn't a need to specify New Zealand in terms of security intelligence agencies, because those terms are defined already in the Principal Act, I understand. But in terms of whether non-New Zealand actors could be said to be working with NZDF such as to qualify for the exclusion, I'm advised that they could be caught by such an exclusion, which may or may not help to assuage the fears of Mr Twyford, or at least to answer the question that he's raised in terms of non-New Zealand actors, be they embassies or high commissions acting in this country. I suspect that there would be important conversations at a diplomatic level if there was any need for activity of that nature, and that would be well above my pay grade, I hasten to add. But I also hear his concern about draconian powers to switch off, and yes, these are important and serious powers, but they're being legislated for a reason, and by the way, I do acknowledge and thank the members opposite, so to speak, who have engaged with the principle of the legislation being important, and of course are asking questions to ascertain the detail. As far as those draconian powers and the segue into the Regulatory Standards Bill, I do wonder if Mr Twyford's signalling his intent to support that legislation, because he's obviously very concerned about the right to compensation. But I would be very surprised if the disablement of Russian ground-based infrastructure were to enable Vladimir Putin to get a red cent, and I use the phrase advisedly, as a result of this regime. So I think he can feel as assured as possible on that point.
Lawrence Sunan.
Thank you, Madam Chair. I have a number of questions for the Minister, because we're still on clause 6 and 7 largely, and there's still a number of areas that should be covered. I want to first pick up on what, thank you, the Minister, for his excellent, as always, response to our questions. And I think to start with, in terms of the review clause, I want to draw the Minister's attention to the Regulatory Impact Statement, paragraph 145, which is around the fact that the Principal Act includes a provision, in fact, in Clause 86 of the Principal Act, it actually includes a 3-year review provision. And the recommendation here is that we propose a similar provision to be included for review of the operation effectiveness of the GBSI regulation regime 2 years after the commencement. However, that is not present in this bill, despite that being the recommendation in the regulatory impact statement. So I just also want to support the amendment paper by Honourable Rachel Brooking on this, because again, it is something that we see stated in the RIS but not reflected in the bill. I just also want to pick up on what the Minister mentioned before and what Honourable Phil Twyford questioned in terms of what happens if we have this 1-year transition period and after that the Minister is able to make these sort of authorizations or have these authorizations or authorize the permit, yes, in some ways, the permit for the operations of GBSI. I want to pick up on what it says on page 10 of the departmental disclosure statement. And I want to just check in terms of the reading here, because it does say the Minister has the power in 4.1 to require an operator to dispose of their interest. But right at the end, it says, and this could potentially go to a district court, the concept to dispose of the interest or right and pay any proceeds of the disposal to the recipient of the disposal order. So would that proceeds also include then, if the Minister wouldn't mind elaborating, on the cost of the interest in its entirety, or at least the market value of the cost of that particular interest as part of that court order? So just kind of pick up on some of the conversations that has been that we've had, and I just want to go into a little bit more detail around there. Picking up something the Minister mentioned last night, and this is a question that I signaled in my second reading, which is in the regulatory impact statement, there were 4 options given to how we could look at managing some of the gaps that we have in the current legislation around GBSI. And the most persuasive options were options 3 and 4. And option 3 is authorization regime. Option 4 is licensing. And the Minister mentioned about licensing yesterday. So I wanted to check with the Minister in the chair today on whether the Minister wouldn't mind elaborating on the decision between why in the end we decided to go with option 3, the authorization regime, and not option 4 in terms of a licensing, because they seem to be, according to the RIS, of equal footing. One of the other questions I had, which hasn't been responded to, is around the definition of authorization holder. And it says in section 5, clause 5, subclause 1, it talks about the person who is the sole holder of a GBSI, whereas I mentioned yesterday that in the Overseas Investment Act, it talks about the possibility of collaborator. So how would collaborator be considered under this legislation when the authorization holder is a sole holder? Without the sole holder naturally encompasses collaboration. Because in the example that is on page 4, it talks about person A and person B, and if person B, for lack of better term, sublet that particular control from person A, the sole holder is still person A and not person B, but it still doesn't go into any elaboration on collaboration, and it doesn't specify in terms of, in this case, I'm assuming the accountability and anything that person A has to answer to, the accountability falls on person A and not person B. So if the Minister wouldn't mind clarifying that. My final question, noticing that I'm very short on time, but I do have another question, if I may, Madam Chair. My final question is around section clause 7, Madam Chair.
Lawrence Sunan.
Thank you. My final question is around clause 7, the new 49A subclause 2A Roman numeral 1. And that is around communicating with a space object. And again, it kind of goes back to what I wanted to ask about accountability, is when we are looking at communicating with a space object and also anything that's relating to a GBSI, you're also in the process of collecting data. And I want to check with the Minister from a data protection and also data sovereignty perspective, whether they will be as part of the requirement for authorization, whether the Minister would consider requiring the operator of GBSI to give a copy or all copies of data collected as a result of operation or be made available as a requirement of national interest. Now, the regulatory impact statement was very clear that the reason we have something like this is mainly for national interest and security, and particularly how it could be used for military purpose. And I think it might be quite an important element for us to be able to at least readily view or make the operator make or require the operator to make the data they collect readily available by the relevant minister in order for them to have the authorization. So those are a couple of my questions. Just if the minister wouldn't elaborate on the fact that why has the bill go against the advice of the regulatory impact, make a statement for 2-year review in paragraph 145. Questions around the collaborator and the definition of sole holder, accountability measures, the difference between authorization regime and licensing, and finally, in terms of the requirement for the availability to review data that's been collected by the GBSI as a requirement for authorization.
Madam Chair.
The Honourable Chris Pink.
Thank you very much, Madam Chair, and grateful to Lawrence Junan for a typically thoughtful contribution from him, and he's flattered into me into giving as helpful a reply as I'm able. At the risk of going round in circles on the point about a mandatory review versus a non-mandatory one, it seems to me clear that the government decision has been around retaining flexibility in terms of the time frame and manner of such a review, notwithstanding that there was advice that there could or rather, could or should be a review specified in the primary legislation, with the rationale being that, as already canvassed with various colleagues, that it will be helpful to monitor the ongoing operation and effectiveness of the Act. There's other ways to skin that cat, frankly. So the government's view is that it's not necessary to specify that in primary legislation. I appreciate that in relation to the particular proposal put forward by the Honourable Rachel Brooking and other comments made in the House that may be unsatisfying to some members of the committee, but I feel at this point I can't take that point much further. In terms of the property rights argument as expressed by the Honourable Phil Twyford, but also with a link to the data sovereignty element raised by Dr. Junan, I think it's worth exploring but briefly the mechanics of what would happen in the event of the measures being triggered within the Act, namely that there is a disposal order that would allow the person issued with it to dispose of their right or interest in an agreed manner, and it might be that the switch be flicked at an agreed time or in an agreed way, and it could include selling those rights or interests, and data, of course, could be conceived as being within the ambit of the rights and interests associated with the physical infrastructure. And then where there is a forfeiture order, on the other hand, as opposed to a disposal order, the Act allows for sale proceeds to be returned to the person. So unlikely as it might seem in the case of hostile foreign actors, for those of a less aggressive or unsavoury element, it might be that it's a matter of negotiation for the New Zealand government to engage in a conversation about the way that the confiscation effectively of property rights not take place, but instead an agreed and mutually beneficial outcome take place, that the evil is avoided without undue impingement on the investment of those who might for non-nefarious reasons invest in ground-based infrastructure. In terms of collaboration and therefore accountability, I'm not certain that there's much I can say about its interaction with the Overseas Investment Act regime, but I would say that the intent of the legislation is to appropriately capture the activities of those who are effectively as opposed to nominally undertaking them. So it's my understanding from reading the legislation that there'd be nothing to preclude us as a nation, us being New Zealand, and the government through its various agencies, from acting in a manner that would reflect the intent of the legislation, notwithstanding that it might be if you'll excuse the legal language, and I know you will, sir, pierce the corporate veil in terms of the ownership and other structures around that. As for licensing versus authorisation, yes, both are possible regimes, and the member rightly points out that these are both contemplated as possibilities within the RIS, and it seems to me that the Minister chose the authorisation route as best reflecting the balance that we wish to have in terms of being empowering but also enabling flexibility and of course balancing those considerations on which we have already touched. And then finally, in terms of the data sovereignty point, I should also add the power under the Act is to seek necessary information, and to ask operators to provide all data wouldn't necessarily be practicable in the circumstances when that arose, whereas particular data could be sought if it's needed. So again, the effort is to provide as much prescriptive enablement of the functions that we all, I think, wish to see provided in legislation, but without constraining ourselves in the manner in that that might take place.
Madam Chair.
Priyanka Ranakrishnan.
Thanks, Madam Chair. Madam Chair, I do have a few questions that I would be keen to put to the Minister. But just before I get into that, and I acknowledge the Minister said he's not going to move on the post-enactment review amendment. I take that point, but I do want to register my emphatic support for my colleague, the Honourable Rachel Brookings' amendment for the reasons outlined by her and by Venushi Walters. And so it is disappointing that is not going any further, given the circumstances under which we are passing this bill. To my questions, I do want to put to the Minister a question that I put to the Minister for Space last night. I did see her nodding, but the House rose before I could get a response, and so I will just lay that out again. And that is with regard to 49C4 B. Well, I didn't get an answer, Minister Ducey, so I have said that. Oh, well, whoever said that? Tim, somebody. Anyway, what I want to know is, with regard to the national interest test and the regard that the Minister needs to pay to national security specifically, it does say in 49C5 that before granting a GBSI activity authorisation, the Minister may consult the intelligence and security agencies about, and it goes on to lay out the risks to national security and then the extent to which the risks can be mitigated through the authorisation conditions. My question to the Minister was why it seemed to be written in a way that it was optional rather than a requirement. So given the emphasis on national security for this piece of legislation, why is it not a requirement to consult with the relevant minister and the relevant agencies there? And related to that, in clause 7, replace section 53(4)A with, in the case of a launch license, and it goes on to list a whole bunch of licenses, and it says, must consult the security ministers in accordance with section 55. And in the case of a GBSI, this is AA, in the case of a GBSI activity authorization, may consult the intelligence and security agencies about those 2 points, the risk and the mitigation to the risk. So just keen for some clarification why that consultation is not a requirement. The other question I had was around what I understand is already happening, which is, and I get that this legislation aims to capture operators and not the host of the GBSI, but I understand that there are scenarios where the host is in New Zealand, but the operator is offshore in a different country, and therefore my question is whether this legislative regime would capture them in that scenario as well. My final question that I want to raise is to tease out a little bit the options versus the funding model that is laid out or touched upon within the RIS. I have read there's a fair bit of detail and analysis around the different options considered, the 4 options considered. Totally take the point that's made in the RIS why option 1, which is the counterfactual, was not the way to go, and option 4 was probably too heavy-handed given the cost requirements there. So I take that point, and it seems to be between 2 and 3, and Minister and the government has landed on option 3. However, when it comes to the funding of the implementation, I would have thought that the concerns around effectiveness would have been both in the design of the scheme, but also in the implementation of this regulatory framework. There is a fair bit of ongoing monitoring that is involved as well, and yet it does say in the RIS somewhere that there isn't specific funding for the implementation of this, and in another bit it says that the anticipated estimated cost is of 2 FTEs at MB. Then goes on to say that the intelligence community may require further resources depending on the number of authorizations, but that they will need to assess as they go. So why wasn't it then perhaps a decision to land on option 2 to then move to 3? Was that considered? Just keen to get a sense of how this is going to be funded, because that leads to the effectiveness of the framework as well.
Madam Chair.
Tom Rutherford.
I move that debate on this question now close.
I would call the Honourable Rachel Brooking.
Thank you, Madam Chair.
Before you begin your call, there is a lot of repetition now starting to come back. It doesn't matter how differently the questions are phrased, we keep a close track of what they're referring to.
Well, Madam Chair, we're all going through this, and as you know, we are in all stages urgency.
I do understand.
And we are trying to work our way through this. And so I have some questions based on some of the Minister's responses so far. So we were talking, I was asking about Mahia and Tāwhaki, and he said he didn't want to make, to get it wrong, to get the answer wrong. I don't mean to be rude there at all, but can he clarify then, the point is, if you already require under the Principal Act a licence or permit for launching, but if you also have space infrastructure, that you will require the space infrastructure authorisation as well as whatever the launch ones are. So that's one question. Then we've been talking a bit about the disposal orders, and the Minister so that's at new 83A, and the Minister just went through that process, and I note that a disposal order would specify any reasonable steps that must be taken in order to comply with the disposal order. So if the Minister can confirm that some of this equipment is very large, and I imagine then, but can the Minister confirm my imagination, that any such order, it's his expectation that any order would go through in some detail how it is that this large equipment would be disposed of. And then I note that the Minister has talked about at subsection 4, the Minister must have regard to New Zealand's international obligations when acting under this section. Are those international obligations the compensation that he's referred to, or is it something more than compensation as well? Is it different trade agreements? Is it different treaties? What does he imagine that section to mean? And then wanting to just link all of that back into these questions about the host and the operator. So there's an authorisation holder must comply with and give a whole lot of information when requesting, when applying for the authorisation. So that's at 49D, new 49D, in clause 7. And I'm particularly interested in E, which is if the authorisation holder operates or proposes to operate the infrastructure to carry out regulated activities on behalf or for the benefit of another person, ensure that the authorisation holder has in place partner due diligence arrangements that meet the requirements, etc. So I know I've visited Space Ops, and just the one in the south, not the one in your electorate, Minister, but this is big infrastructure, and some of those, my colleague Ingrid Leary described them as a Dr. Zeus type thing where the antenna come up and move around, will be controlled offshore. So is the idea that, and so in this case, the person on the ground, which happens to be a CCO, would have to show the relationships that they have with those operators offshore to get the authorisation, and then the regulator would have to be satisfied that there is the right security and arrangements in place, or not satisfied, and therefore they wouldn't be able to operate. So that's of a particular, very real economic importance to those operators, and I've no doubt that they all want to do the best. I'm not saying that, but they will be interested in how these aspects are going to work in practice. So if you've got comments on that and what it is, what thought has gone into those relationships, that the hosts, they seem to be the host to me because they're the people who have the land and they have these. The big bits of equipment are on their land, but they might be being operated, the antennae, the tracking that they're doing of the satellites might be operated from offshore. How is that going to be regulated?
Madam Chair.
The Honourable Chris Pink.
Thank you, Madam Chair. I love a good Dr. Seuss reference, and I feel like there's something in there about the places you'll go that feel like we're in that waiting room on page 7 of that book. No, just kidding. I don't know what page number, but very familiar. Madam Chair, in response to the points made by the Honourable Rachel Brooking, in terms of the disposal of the large physical infrastructure, I think it's a question that I might have anticipated from a Member of Parliament concerned with environmental considerations, and rightly so. I would think, however, that there'd be nothing that would necessarily preclude the disposal of such infrastructure in a way that would be inconsistent with usual manner of disposing of waste, as it would be by that point. And the member will be more familiar with those legislative and regulatory frameworks than me, but it seems to me that it would need to be disposed of thoughtfully, but I don't think that's the matter to specify in this legislation in relation to effectively the data and space-related aspects of how the infrastructure is used. In terms of obligations, international obligations, whether that goes beyond mere compensation, instinctively I would expect that it might, and we can all use our imagination about different international instruments to which New Zealand is a signatory that might become relevant, but again I think it's appropriate in terms of the background documentation and the legislation itself not to attempt an exhaustive list of what those obligations might be for fear of missing out some or unduly emphasising the importance of others in a way that's general, given the particular circumstances might dictate that's appropriate or not. And of course our international obligations do change over time as we enter into and theoretically could withdraw from international obligations of a bilateral or multilateral nature. So that seems sensible to me that we're not more specific about that, but I can't see a reason personally that it wouldn't be limited only to matters of compensation as to those obligations. As for the authorisation process and what would be necessary to demonstrate security and other relationships with non-New Zealand actors, I can imagine well that a thorough process of determining such factors, investigating them, would be necessary for authorisation to be passed. But again, it's not something that I can comment on in terms of the content of the law that's in front of us as to how those discussions might play out in any particular case. And then passing to the points made by the Honourable Priyanka Radhakrishnan, to respond to that point that she's raised regarding whether the Minister for Space should be required as a mandatory basis to consult the Security Minister. She's rightly pointed out that the Minister for Space may, but we're not saying must. That's because in practice consultation will take place between the regulator, which is MB of course, and the security agencies for every authorisation application, as agreed from time to time by Cabinet. So that's, we think, a more efficient approach, requiring consultation that would actually lead to the same outcome than necessarily requiring that particular formal element whereby consultation must take place in a way that's understood by that term. So we think overall the regime will provide for appropriate advice to the decision-making minister, and of course the minister herself or himself potentially in the future would make decisions on behalf of the government in any case. The other points made by Ms. Radhakrishnan seem to me to be around costs and funding, and we think that the effectiveness of the design and implementation is appropriately set. But again, all these matters are not set in stone to the extent that they can be reviewed and should be reviewed in terms of practice as well as the policy over time. And then she's again made the point about the regulatory review proposal, and I'd hate to repeat my own answer on that and thereby risk the whole Committee of the Whole House stage being shut down by the chair, because we wouldn't want that to happen, would we now? But if I were to dwell on it for one more moment, she said she wants to express her view on that. Of course, parties will be able to do that through a vote in due course at some point on the proposal as encapsulated by Ms. Brooking's SOP.
I think there is still room for new material. Lawrence Sunan.
Thank you, Madam Chair. I actually just have quite a small question on an area that we haven't covered yet, and this is Clause 7, the new 49E on ministers may vary, revoke or suspend GBSI activity authorization. And I actually just have a very small question on this. Understandably, the minister may vary or potentially may revoke and suspend a particular authorization, but can I just check if the minister would consider if there's scope, for example, to give a prior warning first to say that, look, you are operating out of the scope of particular thing. Is there going to be some sort of criteria that the minister is going to be looking at when there is a suspension of a particular authorization? So that's actually essentially my question, which is around whether there might be notification period to say, hey, we've noticed something that you're not supposed to be doing. Please correct yourself before further actions might be taken. Or maybe it depends on severity. That's it. You violated it. You get your authorization revoked. Would the minister wouldn't mind elaborating how that revocation would work?
Madam Chair.
Yep. Honourable Chris Pink.
Thank you. I feel as though the period of notification, or rather the mechanisms, already have a degree of flexibility in the fact that there would be a discussion, or could be a discussion, and the disposal of data in an agreed manner could contemplate the opportunity to respond if the minister, acting on behalf of the government for the people of New Zealand, would determine that's appropriate. So it seems to me there's nothing that precludes that, but at the same time we don't want to be so prescriptive in law as in the other factors that have been raised in a way that would be unhelpful in the future.
Bernice Walters.
Thank you, Madam Chair. I just wanted to respond to the Minister's response on a question relating to exemptions. This is actually more to do with the Minister's lack of power in terms of granting an exemption or preventing an exemption on the basis of the Minister's response. So I asked a question earlier about Section 6(2)(b)(1) in terms of who that exemption would apply to, and the response was that it could apply to a foreign actor as well, potentially. My colleague, the Honourable Phil Twyford, asked questions about embassies in New Zealand, and just putting those two together, it feels to me like partners such as our Five Eyes partners could potentially fit into that space. Now, there may of course be times when that is appropriate, that an exemption would be granted. However, on New Zealand territory, it would seem to me that that ought to be a decision of the Minister in terms of the scope of an exemption. Now, I'm not ordinarily one to argue for an increase to discretionary powers, but it just feels to me, in light of the way that clause is drafted, that either ministerial discretion should apply or that the clause should be drafted more closely. And another example of how the clause could be drafted more closely is there's also an exemption for a person who's providing services to the New Zealand Defence Force. That's it. And so it's not couched by more limiting language, whereas I wonder whether the Minister would be open to limiting that, for example, by including the words security or intelligence service to the New Zealand Defence Force. So just wondering whether there is either an appetite for more closely drafted language to ensure that New Zealand is still retaining its autonomy in terms of potential third-party actors, or whether appropriately the Minister should have discretion to prevent an exemption from being granted in certain circumstances, and if so, whether that should be drafted into the legislation. Thank you.
Madam Chair.
Honourable Chris Peck.
Thank you, Madam Chair. I think I understand the point made by Vanushi Walters, but I also think that the discretion could be applied at the stage, or would be applied in practice at the stage that the NZDF would choose to work with the other partners, be they other government agencies of New Zealand, including NZSIS or GCSB potentially, or overseas players. So I think there'd be enough flexibility in the system such that they could choose with whom they work, and therefore to give the Minister either more power or discretion on the one hand, or more tightly constrain her or him on the other hand, therefore isn't necessary.
Madam Chair.
Dr. Vanessa Weenink.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour, please say aye. Aye. To the contrary, no. The noes have it. A party vote is called for. Mr Clark, could you please conduct the party vote?
New Zealand National.
49 votes in favour.
New Zealand Labour.
Tori te kau mā whā e whakahe.
Green Party of Aotearoa, New Zealand.
15 votes against.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
5 votes against.
Members, the ayes are 68, the noes are 54. The question is agreed to. Honourable Rachel Brookings tabled amendment to Part 1, providing for post-enactment review of the bill by a select committee, is out of order as not being in the correct form of legislation. The question is that Part 1 stand part. All those in favour, please say aye. Aye. To the contrary, no. No. The ayes have it. Members... I will call for a party vote. Please, Mr Clark.
New Zealand National.
49 votes in favour.
New Zealand Labour.
Tori te kau mā whā e whakai.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 in favour.
New Zealand First.
8 in favour.
Te Pāti Māori.
5 against.
The ayes are 117, the noes are 5. The question is agreed to. Members, we come now to Part 2. This is the debate on clauses 26 and 27, amendment to outer space and high altitude activities, licences and permits regulations 2017. The question is that Part 2 stand part. Lawrence Sunan.
Thank you, Madam Chair. First of all, I just want to point out again, that this is one of the things that the Minister said yesterday as part of the first reading, that the consistency report against Bora will be available on the Ministry of Justice website. And I want to just, first of all, raise the point that that Bora report is still not available on the Ministry of Justice website. So if the Minister wouldn't mind looking into it. Now, my question is around Clause 27, Regulation 3 amended. Now, understanding that when we're looking at the license and permits, the revocation of the definition of protection security arrangement, as expressed earlier, is due to the introduction of the authorization regime, particularly when we're looking at the activities under permits and licenses is replaced by the definition of protective security arrangement inserted into Section 4 of the Principal Act by Clause 5, that is also covered activity under GBSI activity authorization. And again, just going back to the regulatory impact statement, when we're looking at Table 1 on page 8, which covers what the existing regulatory environment is and non-regulatory environment versus what the authorization regime will be doing. My question to the Minister is, by revoking, just another piece is, we already see that there is still a degree of overlap between, for example, the new authorization regime as well as other legislative environments such as the Overseas Investment Act around collaboration with overseas parties. Can I just check with the Minister as a reassurance that the revocation of the protective security arrangements in the outer space and altitude activity licensing and permits regulations isn't going to create a gap in the regulatory environment that the authorization regime doesn't cover? So is there any possibility that we inadvertently created a separate gap?
I call the Honourable Rachel Brooking.
Thank you. Very simple question for the Minister, because as you will be aware, Part 2 of this bill is very, very short. And what Clause 27 does is amend an interpretation in the regulations. And just to make sure we're all talking about the same thing, that regulation has a definition of protective security arrangements, and it seems that the definition, in the regulation is very, very similar to the new definition that is coming through in this amendment bill, and the only difference is that it now refers to an authorization. So my question is, am I right? Is the point of this clause in Part 2 simply to delete the secondary instruments definition because it's now going to be in the primary instrument?
Madam Chair.
The Honourable Chris Pink.
Thank you. Just to respond to the question posed by the Honourable Rachel Brooking, that's my understanding, yes, that's the intent of what lawyers call a switcheroo, of course, whereby revoking their definition and at the same time as creating the new definition within the primary legislation will be so as not to create a gap. So I think we're on the same page with that, and a fair point, of course, to seek clarification. And a fair point as well, Dr. Lawrence Junan raises around coverage or the possibility of a gap between this legislation and the Overseas Investment Act. That's a piece of legislation in which I take a certain degree of interest as the Minister for Land Information, wearing another hat. I'm currently moonlighting for the Minister for Space. Some might unkindly call me a space cadet, but I'm sure that wouldn't be a phrase anyone else would agree in any other context. But as Land Information Minister, I'm naturally interested in the operation of the Overseas Investment Act, and it seems to me if the passage of this legislation were to result in any kind of mismatch or undesirable duplicative coverage, or more importantly a gap, then that would be a matter that we can and should review. So I'll take that as a helpful point from the member. And then in terms of the New Zealand Bill of Rights Act vet, it's unfortunate if the member doesn't have access to that, and by way of being uploaded to the Ministry of Justice website. This is something I've encountered myself before, and it's not a particularly helpful situation, but for what it's worth, I can relay to the member at least that my understanding is that the vet passed, which is to say that there's nothing in this Act that was considered to be inconsistent with the New Zealand Bill of Rights Act.
I'm so sorry. Koshla Tangati Manuel.
Tēnā koe e te māngai. Tōtai tēnei te mea tu ki a koe e te minita. Who called you a space cadet? How unkind. Anyway, oh, you called yourself a space cadet, okay. So So, Madam Chair, no doubt there will be continued discussions about the role of kaitiakitanga of space. Hoi anōra, we are talking about ground-based space infrastructure, te whenua, tai noa mai ki te mana whenua. So, I want to acknowledge Rocket Lab, obviously a shining star and part of my electorate, the beautiful Te Mahia. And one of the things, while they stand out, they support over around 12,000 jobs, which is always a great thing. But we've learnt some excellent lessons from Rocket Lab in terms of working with mana whenua. While neighbours such as Tawapata Station happily coexist, throughout the establishment there were concerns around cultural impacts, environmental impacts, access to moana, consultation concerns. You know, some people felt as if the process was rushed, and genuine engagement. So as we look at point 9 on part 2, about anyone, they must be granted a GBSI activity authorisation for the operation of GBSI for the activity. My question to the Minister is, knowing what we know from the establishment of Rocket Lab, how will Māori landowners or mana whenua be involved throughout the process, not just in consultation about establishment of the GBSIs, but the ongoing monitoring of the licences? And indeed, any neighbouring landowners, not just mana whenua, because I think that's a concern for anyone who is a neighbour of such establishments, especially when space is still the final frontier for a lot of people. And so this might just seem a bit outlandish for landowners and neighbours. So also the consideration of wāhi tapu, sacred land, how that's going to be, if at all, taken into consideration, and, as I said, environmental concerns. Koera, aku pātai mō tēnei wā.
Kia ora. Madam Chair.
Call the Honourable Chris Payne.
Thank you, Madam Chair. Just to acknowledge the points made by the member, it's positive to hear that there have been constructive relationships locally with the operation of Rocket Lab, whom she's rightly acknowledged as a significant employer, but also a major player in terms of the activity within that part of the world, and the engagement with local iwi sounds as though that has been very constructive. Broadening out the conversation in terms of new ground-based space infrastructure, it seems to me that our resource management laws and requirements and regime more generally, and decision making outside the remit of this legislation will continue to govern that. I take the member's point that this is important not only because there is a land-based element, or the ground-based or whenua aspect of what is included within the remit of the bill, but also the cultural aspects and the access to the moana, etc. So just to acknowledge those points, but say I don't think that it's necessary for this legislation to contemplate some sort of new way of understanding what should be approved in the first place, or the ongoing interaction, because that's covered elsewhere within our statutory frameworks.
The question is that part 2 stand part. All those in favour, please say aye. Aye. To the contrary, no. No. The ayes have it. A party vote is called for, Mr. Clark.
New Zealand National.
49 votes in favour.
New Zealand Labour.
Tori te kau mā whā e whakai.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Rima ngā poti whakahe.
Members, the ayes are 117, the noes are 5. The question is agreed to. The question is that the schedule stand part. All those in favour, please say aye. Aye. To the contrary, no. No. The ayes have it. Party vote is called for, Mr. Clark.
New Zealand National.
49 votes in favour.
New Zealand Labour.
Tori te kau mā whā e whakai.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Rima ngā poti whakahei.
The ayes are 117, the noes are 5. The question is agreed to. Members, we now come to the final debate. This is clauses 1 and 2, title and commencement. The Honourable Rachel Brooking.
Thank you, Madam Chair. Again, a very short part, and I have one question on clause 1 and one on 2. The first one is about the title, and it's just the Outer Space and High Altitude Activities Amendment Act, and whether the Minister would consider any amendments or changes to put in some brackets there and put something like regulating ground-based space infrastructure after activities and before amendment, just so people, when they're looking for the amendment, might be able to find it more easily, because it does seem that all of our discussion has been about that ground-based space infrastructure, with its quite odd to say acronym. Then on the commencement date, my question is around that it comes into force on the 29th of July 2025, so that is next Tuesday, and that late July date, not necessarily Tuesday the 29th of July, but late July, has been bandied around by the Minister for some time now as being the time that she wanted this legislation to be enacted and enforced. So my question is, why is it that we only saw the legislation yesterday and that it's under all stages urgency when it has been in train and progress for some time? And, you know, we accept that this legislation is needed, we're supporting it, but it could have been in the House last week and been with the Select Committee over the weekend and back in the House this week, for instance. And we know that there's not a huge amount of people in the country who know about ground-based space infrastructure, but there are some, and it would have been useful to get their views on this and to make sure that we were asking the good questions about it. So that is my question about the commencement date and also about the title.
Honourable Lawrence Sunan.
Thank you, Madam Chair. I do have a very quick question for the Minister on Clause 2 on commencement, but from a different approach to the Honourable Rachel Brooking, because I agree with Honourable Rachel Brooking that the question that she asked around the commencement date is an important one, particularly in light of the fact that we do see that the consultation with the operators has been done since 2024. So this is something that's been in the train. However, my question is, this is being brought into the House under urgency, and all stages of urgency, because citing that this is something that is potentially will create security risk, is in the best interest of our national interest and all of those, yet the commencement date isn't the day after royal assent, but instead it is next week. And I just wanted to check if there's any potential, like what could happen in the time that now people know about this, because again, the House didn't know about this bill until this bill was placed on the table during first reading. There was no heads up, no way for anyone to know, including the New Zealand public, because of the national security risk. But yet we are now left with 4 days of people, 5 days of people knowing that this is something that's happening. So what is the potential risk from now until the 29th of July? And why was the commencement date not the day after royal assent?
Madam Chair.
Honourable Chris Pink.
Thank you, Madam Chair. Just to address the two time-based elements, I take the point made by both members actually in terms of the time frame, but it's probably helpful to note for the record by way of background that consultation with existing ground-based space infrastructure holders did take place in the formulation of the policy and perhaps even in terms of the drafted outcome for that policy, and likewise with a couple of experts in the space. So I take Ms Brooking's point that there are some others in New Zealand, albeit a limited number, who would have expertise to speak in the space, and no doubt, again, without rehearsing old ground too much in terms of the ongoing nature of review of the operation and effectiveness of the Act, I'm sure that it will welcome hearing any well-informed opinions about the extent to which that is working well and as intended. As for the time frame element that Dr. Jinan identifies, I suppose whenever there's a gap between commencement or the passage of a law and it becoming effective in the real world, there is a possibility of actions taken in contemplation. The fact that it's a relatively short time frame, I think, mitigates as best as possible the risk that particular activities ramp up in the meantime. But of course, that's at the same time an argument against having a long lead time for the legislation to be coming into effect. We don't want people to take contemplation of this in a way that takes advantage of a gap that's now arguably highlighted by the fact that we're now discussing and identifying a potential vulnerability in our arrangements. Finally, as to the name of the bill, I suppose it would, one can always be more explicit about the contents of a bill within its title, but the length of it already is considerable, and hopefully it will be reasonably obvious to those reading the bill, and for anyone who's minded to be even more diligent and read the Hansard of this discussion. They'll get a pretty good idea, I think, of what's in it.
Tiana Tuiano.
Thank you, Madam Chair. Just a quick question around, and I was listening carefully to the Minister around those different timeframes. We had that consultation process with around 21 of the entities that are GSBI. And then we've got this, and now we're at this particular point here. So just for clarification for the House, did something happen between awareness from those discussions with these different entities, and that is why we're in this situation moving through urgency? I think that'll help to sort of alleviate some of the questions that we're having around the House in terms of that gap between that consultation process that happened and the fact that we're moving through urgency at this particular time and looking at the 29th of July as the commencement date. So a quick question there. The other thing around, and I support what the Honourable Rachel Brooking was saying around making it easier for people to be able to find this amendment. You might want to not use the entire sentence, because I get what you're saying, it's a paragraph, we don't want that, but you could have GCSBI or whatever it is as the acronym to make it easier to find folks. Just a helpful suggestion for the Minister.
Madam Chair.
The Honourable Rachel Brooking.
Thank you, Madam Chair. Just in reflection, thank you to the Minister for answering my questions before. I just want to put it to the Minister that does he agree that there is a difference between consultation on policy versus the drafting of the full and final bill? Do words matter?
Madam
the Honourable
Chair,
Chris Pink.
I'm happy to confirm for the Committee of the Whole House that words do matter. And as for the period of time between the consultation taking place and the substance of the consultation and the timeframe of the effectiveness of the legislation, there's no particular insight I have in terms of what was consulted upon that led to that timeframe being specified as the 29th of July 2025.
Madam Chair.
Tim Costley.
I move that debate on this question now closed.
The question is that debate on this question now closed. All those in favour, please say aye. Aye. To the contrary, no. The ayes have it. Party vote is called for, Mr Clark.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 opposed.
Green Party of Aotearoa, New Zealand.
15 votes against.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima nā pōti whakahei.
Members, the ayes are 68, the noes are 54. The question is agreed to. The question is that clause 1 stand part. All those in favour, please say aye. Aye. To the contrary, no. The ayes have it. A party vote is called for, Mr Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
Tori te kau mā whā e whakai.
Green Party of Aotearoa, New Zealand.
Te kau marima na poti whaka-ai.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima na poti whakahei.
The ayes are 117, the noes are 5. The question is agreed to. The question is that clause 2 stand part. All those in favour, please say aye. Aye. To the contrary, no. The ayes have it. I will report this bill without amendment.
The House is resumed.
Madam Speaker, the committee has considered the Outer Space and High Altitude Activities Amendment Bill and reports it without amendment. Madam Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. To the contrary, no. The ayes have it. This bill is set down for third reading immediately. Honourable Chris Pink.
Madam Speaker, thank you. I move that the Outer Space and High Altitude Activities Amendment Bill be now read a third time. Thank you to all members for their contributions during the first and second readings and also for the thoughtful debate that we've just experienced during the Committee of the Whole House stage. Madam Speaker, this bill represents a significant step forward in strengthening New Zealand's space regulatory framework. As our space sector continues to grow, so too does the need to ensure that the ground-based infrastructure, such as satellite tracking systems and telemetry systems, are subject to appropriate oversight and standards. Ground-based space infrastructure plays a vital role in supporting satellite operations and space activities, but without regulation, it can pose risks to national security and other national interests. This bill ensures that operators of such infrastructure are authorised, accountable and operating in a way that protects New Zealand's interests. Madam Speaker, it's been done because it is needed, quite simply. During the past 5 years, there have been several deceptive efforts to establish and or use ground-based infrastructure in New Zealand to harm our national security by foreign actors. They've deliberately disguised their affiliation to foreign militaries and misrepresented their intentions. To date, these risks have been managed through non-regulatory measures, including relying on the goodwill of ground-based space infrastructure operators. These measures are no longer enough. Passing this bill establishes an authorisation regime for ground-based space infrastructure backed by enforcement powers to safeguard the national interest. It also provides for a transition period, allowing operators to meet the new requirements while ensuring that the responsible minister, being our colleague and friend, the Honourable Judith Collins, the Minister of Space, to act immediately if risks arise. The bill will therefore help maintain New Zealand's reputation as a trusted and capable spacefaring nation, one that takes its responsibilities seriously and is prepared to manage the risks and opportunities of space activity here on Earth. I'd like to thank the teams at the Ministry of Business, Innovation and Employment and the Parliamentary Council Office for their work in supporting the passage of the bill. I also acknowledge the contribution of stakeholders who helped to shape the policy and ensure that the regime is practical and effective. Thanks to the MPs across the House who have supported the bill, and again for those who engaged thoughtfully in the debate of the Committee of the Whole House. I commend this bill to the House.
Madam Speaker.
The question is that the motion be agreed to. Honourable Rachel Brooking.
Thank you, Madam Speaker. So as the Minister just noted, this is a bill that Labor has been supporting because we do agree that space activity should always be in the national interest and that it's an important part of our economy. And I guess a lot of people will think about space and the first thing you think of is the rockets launching off, and then you might think about what it is that they are taking into space. But we don't probably spend as much time talking about this ground-based space infrastructure that does the tracking of those satellites that are deployed into space by the launch of that is regulated when it comes from New Zealand. So now this ground-based space infrastructure will also be regulated, and that is a sensible thing. I do want to briefly comment on an amendment that I'd put up during the committee stage of the debate that was ruled out of order, and that was about a post-enactment review. And it doesn't matter on the form of it, it is the general idea that whilst we accept that there is a need in Labor, we accept that there is a need for urgency in this case and to go through all stages urgency because of what is best for our national interest and our security interest. We accept that. So we can have both things though, Madam Speaker. We can have both something going through urgency and getting the benefit of the national security that it will bring by it being passed and commencing on next week on the 25th of July. But we can also spend a bit more time on the bill with a post-enactment review, and that the government had an opportunity to not use all stages urgency in a cynical, negative way, which I say this government often does, but they had the opportunity to say, we're actually using urgency for a good reason this time, but we do acknowledge that it is not a great way to make laws. And so to fix that not great law-making aspect of it, we will have a post-enactment review. But the government has chosen not to do that, and I implore them, anybody who is listening, that there is still an opportunity to put this to a select committee in some form or other to make sure that it does have the proper scrutiny. We heard from the Minister and we saw in the RIS that we only saw once the debate on the all stages debate on this bill started, we saw in the RIS that some groups of people have been consulted and they were consulted on the policy, and the Minister and the Chair just before alluded to the fact that some of them might have seen some drafting as well. But they have, it is unlikely, and I do not know, but I am assuming that they have not seen the full bill as drafted for comment on before they saw it as it was introduced last night. And that is a shame, because words matter and we don't want to get them wrong. I still didn't have a clear answer from the Ministers and the Chair about the relationship of the people who own the site and own the land to other operators that might be coming in and contracting with them. I understand that it looks to be when that landholder, the person who has the space, the ground space, when they are applying for their authorisation, they have to demonstrate that they have the correct, have done the correct due diligence for national security for anybody who might be using some of their equipment from time to time. But and I think what happens then is that if the operator of that equipment is largely offshore or a different entity, then that different entity will have to get their own authorisation as well. But again, that is something that could have been worked through, and unfortunately, the National Party backbench MPs kept jumping up to call in a closure motion in the committee stage. And that is very disappointing when this is all stages urgency and we were trying to make sure that we all understood this bill. So I say to them, shame on them. That is just really shows a terrible understanding of how unusual it has been in previous parliaments to do all stages urgency of a bill. But of course, this is a term.
All right, that's a barrage, not an interjection.
Oh, I'm hearing it's fake news because I've got a lot of statistics on this, and all stages urgency has been used by this government time and time again, and this is the one time that I've come across where it makes some sense. And we are agreeing to the all stages urgency, yet members opposite still jump up and try and close down these very civil, thoughtful debates. And what does that say about their attitude to lawmaking? It is just arrogant. That is all it is, arrogant and not wanting good lawmaking. Oh, I'm asked now, when was that view in the last government? Well, the last government didn't do all of this all stages urgency, and I can provide the member those numbers if he wants.
I think we can have this debate. Oh, sorry, we have a point of order from Tim van der Molen.
Yeah, Madam Speaker.
I was halfway through making a statement, so if it's relevant to this...
Yeah, no, I was just pointing out that that was a factually incorrect statement, and I suggest the member might want to withdraw it from the House.
Well, look, I think the member's stated a view. She hasn't put any numbers on it. She's just made the observation that the urgency, the closure motions have been called, and she's expressed a view. She hasn't made any statements about the frequency in a number form, but what I was about to say is that this is away from the actual bill itself, the debate that was going on across the House, so we'll give the member a chance to finish her third reading debate.
Thank you, Madam Speaker. And my point remains, and I'm happy to give information to the members across, that there is a lot of legislation that has come through this Parliament in all stages urgency, and it does not lead to good lawmaking, and they should take that seriously. No, very much unlike the last government,
The
Mr.
member's
Mooney.
made a point. Now we'll come back to the third reading.
Very
Thank
different.
you.
So, I've noted that some of the issues that I don't think were well traversed in the committee stage, and that is a shame. But I've also noted that the space industry is important to New Zealand, as is our national security. So that is why Labour has been in support of this bill, if any of the members opposite had been listening. And I will end my contribution there.
Thank you.
Oh, that is a
Tiano Tuiono.
Madam Speaker, thank you, Madam Speaker. I rise on behalf of the Greens on this third reading on the Outer Space and High Altitude Activities Amendment Bill. And for those just tuning in today, this is a piece of legislation which establishes a regime for GBSI, ground-based space infrastructure, and imposes an authorisation regime on persons who operate GBSI, which is what we're calling it these days, to carry out activities. The activities include telemetry, tracking and control, including of activities that could disrupt satellite operations of space objects, space surveillance and identification of space objects, satellite data reception and other activities of concern if prescribed by regulations. This is passing through all stages with it under urgency. We began talking about this last night. We had an interesting discussion with the Minister through the Committee of the Whole House stage, and what the Minister told us and what we have accepted is that the bill is being introduced as a response to the assessment of the NZSIS of the security threat environment that found New Zealand organisations have been approached by entities seeking to develop space infrastructure. These entities claimed that infrastructure would be used for civilian research purposes, but was subsequently found that the proposed activities could have assisted foreign military activity with potential risks to New Zealand's interests. That assessment also talked about, and I quote, the full capabilities and some of the affiliations of these entities were deliberately hidden. If these projects had gone ahead, we would have inadvertently allowed another country to install equipment in New Zealand with a plausible military or intelligence functions. To have done so would have risked New Zealand's sovereignty. By hiding the affiliations, the foreign entities undermined New Zealand's ability to make informed decisions based on our national security and national interests. So there's an obvious gap there, and the Greens support that if you're going to build something in someone's backyard, it's important that we have eyes over that. There is a regulatory gap, so making sure that there's some regulations in place is incredibly important. There were also very good questions that were posed as well. For example, I know a number of people will want to know of when was this threat become known, because as through our discussions and through the Department disclosure statement, we did find out that there had been actually discussions with 21 GBSI operators, and that began in 2024. So there have been ongoing discussions with 21. That's actually not a small number. That's a few people that are doing this. And so I'm guessing that through those discussions, something emerged, which of course is why we find ourselves in urgency at this particular time. So accepting that premise from that side of the house of why we're here in urgency. I do support what was said, I think, very well by the Honourable Rachel Brooking about having post-enactment review of some kind. The issue is when we go through urgency like this, you do want to make sure that all the nuts and bolts are, holding the wheels together to the wagon, and so that we can have the best, most robust legislation that we have. And that's whether you support the legislation or don't support the legislation. When we plug something into the legislative system, we want it to be the best it can be, the best possible that it can be as well. We also had some really interesting discussions around the authorisation regime, and there were 4 options, and we heard through the various reasons why this particular regime was the one that was picked, and I guess there were some interesting discussions there, and some questions that I continue to have around exactly what happens, because we're in a very fast-moving world where somebody might be a GBSI operator, and that's what they're doing, and then they on-sell to another group, and then they on-sell to another group, and what is the actual parts in place to ensure that that there is proper oversight over that, but also if there are nefarious foreign actors, if I can put it that way, that are actually influencing some of these GBSI operators, that we need to make sure that there is oversight over that as well. There was also, I think, and I think this is where I have some unease on this, but it's an unease which is out of the scope of this amendment bill, but it is definitely connected to it. And I think the Honourable Phil Twyford mentioned this a number of times around the national interest element of it. Because of course we don't want people building stuff in New Zealand which is against the national interest, which could be harmful to Aotearoa, and so making sure that we have a regime that is in place so that we can do that is important. But it gets difficult when we have different interpretations of what the national interest is. And in the regulatory impact statement, it talks about ground-based. We need to be careful of foreign actors that do not share New Zealand's values. Well, the question I have is, what are New Zealand values? Those things develop over time and they evolve. And we do, I think, as parliamentarians, want those values to be the best kind of values. And many of us often make the point that we're in the Pacific. We're New Zealand, we're a Pacific nation as a part of a family of Pacific nations, so making sure that we do everything that we can do to take care of our neighbourhood is an important thing to do. And outside of the Pacific, things are changing incredibly rapidly. We had a ministerial statement yesterday about the situation on Gaza, and a number of countries that would typically align themselves with the US have spoken out with what's happening in Israel. Does that show that that our New Zealand values are changing? Are they developing? I hope so. And I think evolving values in a way which puts people at the heart of them is incredibly important. There was an argument around having more specificity in terms of what the national interest is. There is part of that in this amendment bill, and I think there's like 3 or 4 aspects, but the argument was made, well, You could be more specific. So, for example, with the launching of payloads, you can't launch things up which will contravene our nuclear-free legislation. That makes sense. You can't do other things which will cause environmental impact on other satellites in outer space. That also makes sense as well. So I think you can be prescriptive, but I think in terms of making sure that you have some space to allow for our values to develop in a good way is also a good thing as well. And so that part, although outside of the scope of this amendment bill, is foundational to the entire Act as well. So I hope that the Minister takes on board those points of clarifications, which I think would make this a stronger piece of legislation. The other thing that was not answered at all, I felt, was the part around the role of tangata whenua. A few years back, I did go up to Mahia and to talk with the whānau up there who were unhappy with Rocket Lab was doing. They had said it was one thing, and next thing you know, other things were happening and it was impacting around the wider community. Yes, they might be funding this, that and the other. However, the intention around making sure you take care of the environment and don't launch military payloads on behalf of foreign actors, the US, is an important point that had been made to me repeatedly when I had visited with them as well. The other thing that the Minister also talked about, and we've talked about for some time, was around the exemptions. So the New Zealand Defence Force, they get an exemption. And so my understanding of it is if you've got a Waihopai type situation, that exemption applies. But if you've got a Mahia Rocket Lab situation, that falls under the Act. And so I didn't get actually a lot of clarity from the Minister whether that distinction was correct or not. So if people on that side of the House could clear that up, I think that would be really good for people that are watching this at home. So on that, Madam Speaker, I commend this bill to the House.
Dr. Panjit Pama.
Thank you, Madam Speaker. Madam Speaker, I'm taking this call on behalf of ACT to support this bill. Madam Speaker, we just had the committee of the whole House before this reading, and it was really good to see that Minister answered questions that came from various members. And I can fully understand, as this bill is going through urgency, members had lots of questions, and those questions were addressed in the committee of the whole House. And it is totally justified that this bill is going through urgency, given we know that there are risks, and these risks are real risks because through the ground-based space infrastructure, we know that some entities, while they are using this infrastructure, this technology, for everybody's benefit, this technology can also be used to strengthen their own space capability while degrading others' capabilities. And that's the big risk that we have, and we cannot let anybody compromise or undermine our national security. So this bill is about ensuring that we are protecting our national security, protecting our reputation, because when we talk about national security, it's not just our country, but it's the entire region as well. And also it puts everybody on notice, because from next week, all the authorizations will become a transitional authorization. So basically they will be on notice and they will have to prove that their activities align with our national interest. So it's a great bill, Madam Speaker, and I support this bill and commend this bill to the House. Thank you.
Andy Foster.
Madam Speaker, thank you. I'm delighted to rise on behalf of New Zealand First to speak in support of this bill in the third reading. Look, it's very, very clear, Madam Speaker, that space is a rapidly evolving environment. And what we've heard in terms of that rapid evolution goes to the need for speed in terms of this legislation. And also that we've heard from the Minister, in fact both Ministers who've supported this bill, that there have already been malicious operators seeking to take advantage of what is a gap in our legislation as it is at the moment. It's been great, Madam Speaker, also to hear these stories about and to see the numbers about how important the space industry is now to New Zealand across several parts of our country. We've got a fantastic range of entrepreneurs, and it's typically New Zealand to have innovation, and space is no exception. In the 5 years to 2024, we've read that the The space sector grew by 53%, and it's now almost, or at 2024 was $2.5 billion contribution to our economy, and that is only going to rise. But that means it's really, really important that that sector is regarded as trusted and is regarded as reliable. And so this legislation in a sense also helps not only our national security, but also our national economy. I've heard comments made about Rocket Lab in particular, having visited them a few months ago. What I did see and hear is how important, the importance that they place on both employment but also training and development of local people, and I thought that was absolutely fantastic to see around the Mahia Peninsula. Madam Speaker, this is an amendment bill. The 2017 Act, which it seeks to amend, is very, very focused on the things that we send into space, the payloads that we send into space. And I think what this bill is doing is it's identified that there is a sizable gap about the space-related infrastructure which actually sits on the ground and communicates, if you like, with the satellites that are sent into space. And satellites, Madam Speaker, are now an essential part of so much of what we do, whether it's communications, whether it is navigation, weather forecasting, scientific research, being able to watch sport, all of those things, satellites make a huge difference. What are some of those things there? We've got relaying signals, broadband internet if you're not on cables, secure financial transactions, that's very, very important, global positioning, GPS, real-time tracking of vehicles, deliveries, all of those sort of things, aviation and maritime safety, surveillance, search and rescue, environmental monitoring. There are a huge number of things which satellites are part of, but they're also used, Madam Speaker, for less productive, more malicious, more nefarious, more aggressive purposes, and that's what this bill is about, trying to make sure we have a means of dealing with. I think that we all now understand that New Zealand is in a strategically important location for space. We are an island in the middle of the Pacific, which means that there's not a lot of other places for you to base this kind of ground-based infrastructure on. You know, Australia's a long way one way and South America is a very long way the other way. So we are an important location also in relation to the South Pole. I think we also accept that there are now increasingly malicious operators who would like to disrupt things and would like to launch things from our sovereign soil, and this bill is about making sure that that does not happen. We want to ensure that our national interests are protected, as well as those of our friends and neighbours, and to ensure that we as a nation remain a reliable, trusted partner which upholds the law, and that is also good for the businesses which operate out of New Zealand. I commend this bill to the House.
The next call is a split call, Tākuta Ferris.
Te pika, māku ngā kōrero mo te Pāti Māori, o tira te iwi Māori, mo te anga o tēnei pere. Nō reira, kaua koe mā harahara mo taku hāte. Tēnā tātou. We do not support the bill. And it's for a fairly straightforward principle. It's a principle of Te Tiriti o Waitangi. The bill, not its predecessor nor the amended bill, mentions anything about Te Tiriti o Waitangi, about the partnership that Te Tiriti o Waitangi created, or the place of Māori in it. And whilst we might be here talking about space in an emerging field of technology and an emerging economic opportunity, this lesson has been tracked, learnt time and time again by this Parliament. We arrive to a new technology and then the Parliament takes the view that, Māori don't have anything to do with that technology. Don't have anything to do with that. This was the same thing happened when the Spectrum case came up in the early 2000s. The Spectrum case and the somewhat arrogant view of the government at the time was that Māori didn't have any use or history in the use or utilisation of the spectrum. This would ultimately be disproven, right? This would be disproven. So here we are again. The basic principle is here we go. We've got the 1840 guy over here. What were the ancestors of the Brits doing in 1840? Not a lot in space. So the principle is the same. The principle is the same. Okay, the principle is the same. I hear the supporters of the myth of technology idea over here on my left. Astounding. So a new resource is available. There's some regulation wanted for it, being proposed for it, and Māori are being regulated out of it. It's worth billions of dollars into the future. Yeah. Oh, Ngāi Tahu did very well out of it. We're sticking to the root facts here. Māori have a long cosmological history. They have deep knowledge. We've been navigating the biggest ocean in the world for 10,000 years using the stars. We've managed to name every planet, every constellation. Māori, so has everyone else. The attitude of this House when it comes to this type of discussion is deplorable. It's deplorable. It's a joke. It's an utter joke. The attitude of this government, the House isn't built to facilitate the Tiriti o Waitangi conversation. I can say that to the Speaker absolutely 100% knowing that. This House isn't built to facilitate the Tiriti o Waitangi conversation. And this government isn't interested in the Tiriti o Waitangi conversation. So they keep spewing out stupid views that I'd love to take a little bit more time to rip to bits, but we don't have it right now. But anyway, a great mentor of mine, an uncle, Moana Jackson, he spoke about colonial myths a lot. And one of them was the myth of technology, Andy, the myth of technology. And that the colonial settlers and the successive governments and power structures of this country built colonial myths into our history. And one of them is the idea that all Māori development halted in 1840, and that's where we should stay. You should go and look up the myth of technology, e hoa ma. Go and look it up. Go and look it up. I know about tāwhaki. I know about mahia mai tawhiti. We know about all of those things. I also know about ihirangaranga. Okay, I also know about mātairangi. I also know about things like matariki. Everyone knows about matariki now. But, here we go. Here we go. No decent debate from this side of the House. Just slanging stuff. Slanging stuff, eh? So, I'll just give them a minute to simmer down. I hope everyone's just listening, although you can't hear at home. I hope everyone's at least getting a feel of the attitude here when I'm raising quite a simple point, a simple principle, and it's the principle of Te Tiriti o Waitangi. This House has passed laws that protect these rights that Māori possess. You've passed laws, okay? And here you are just riding roughshod straight over the top of them. Nō reira, kia kaha koutou, we do not support the bill at all.
I've got a point of order from Stuart Smith.
Madam Speaker, I'm not going to raise a point about the member not addressing the bill, but I am going to raise a point of order in regard to wearing a political slogan on the the previous speaker's shirt, and which has a logo as well. And if that's the ruling, I'd just like some clarification. You don't need to give it to us now, because we could all wear T-shirts in the House with party logos and slogans on them, but I just want to know what that ruling is. So
yeah, I can't see a party logo from here, but I can see the member has a T-shirt with something on it, but it's not visible from the chair. I don't know if it's visible on the TV screen. So if the member wishes to speak to the point of order, I'm happy to take that.
Speaking to the point of order, I'm not sure who the sovereign party is. But I do know that the Deputy Principal's been, the Deputy Prime Minister has been pulled up in this House about 3 or 4 times for wearing his ACT pin. So, if you want to come and clear that up, you're welcome to it.
Look, as long as it's constructive, I'm happy to follow up, but there is no visible party branding on the member who was just speaking that I can see from here.
Sure.
Cameron Luxton.
Madam Speaker, the member's using a tactic that's well known in bullying circles to raise a different issue when there's an issue on the table, and point of orders are heard in silence.
Yeah, look, I tell you, the member has been attempting to make a speech and has had a lot of barrage and interjections from this side of the House, which I think it's been coming from both sides, and I'm not prepared to accept that that particular member has been directing what he's been saying at this, other than to react to interjections.
Thank you, Madam Speaker. And,
Just a moment, we've got a member on his feet.
Also, the member just, as the chair has acknowledged, it's hard to read the item, what is written on the shirt of the member. The member did actually just refer to what was written on the shirt, so it would behoove the House to look at Standing Order 119 in regards to what the member has just said as to whether that is an affront to that.
I'll follow that one up. Thank you. Taku Te Whereas.
With regards to the first part of the member's speech or point of order over there, deeming the relevance of Te Tiriti o Waitangi to a debate in this House some sort of act of bullying and not being relevant to this bill is one of the stupidest things I've heard to date.
That actually wasn't a point of order. I'm going to shut this down now. I accept that there has been some to and fro going from both sides, and as I say, when the member was actually making his speech, there were a lot of interjections coming at him, which made it hard to speak, and I'm closing down the point of orders now. I'm accepting that I can't see what's on the member's T-shirt, and I'm accepting that I cannot see any political logo, and we're going to move on.
Madam Speaker.
Dr. Lawrence Junan. No, I know I've ruled, and I've ruled, and I'm moving on, and I've called Dr. Lawrence Junan to make his participation.
Thank you, Madam Speaker. Who knew that this bill introduced an urgency could be so contentious? I rise on behalf of the Green Party to speak on the third reading of this bill. And I want to start by pointing out that though this bill, the Green Party does support this bill from the perspective that it does address a gap within the current regulatory and non-regulatory environment that would be beneficial from the perspective of our security, but also from a so-called national interest perspective. So it is important in that regard, and I want to point out a few things that we have discussed during the committee stage. And it doesn't mean that there aren't concerns that we have regarding this bill, and particularly around the regulatory making power of this bill. Firstly, regarding the urgency that we see in this bill, we did ask the minister that if there were consultation on this bill since 2024, they have consulted with 21 operators according to the departmental disclosure statement. Why was this bill introduced under urgency? There is the idea of, yes, there's security risk, but then we also pressed to ask if they had the time to consult with 21 operators since 2024, why were there no Māori Hapua Iwi collective that were consulted as a requirement of this bill? That was not fully clear as a part of that committee stage. So that's the first thing that we wanted to address. The second part, when we're looking at, in the context of GBSI or ground-based space infrastructure, the other thing that we're asking is this does give the minister a lot of powers in terms of approving those authorization. One of the clearest things, and this from the perspective of regulatory making power and also from the regulatory review committee, it will cause some nervousness. And the fact that the minister, in the end, despite the fact they talk about flexibility and all those, it is clear they did not take on the departmental recommendation in clause 154 of the regulatory impact statement to put in a review period. Now, the regulatory impact statement was very clear. They recommended a 2-year review period because something like this is very new internationally. And that will also be in line with the Principal Act, specifically Section 86 of the Principal Act around the review period, which was 3 years in the Principal Act. So there will be things that people are going to be picking up as a result of this. Now, the third point I want to address is that we do constantly go back to the idea of national interest, and we do acknowledge Aotearoa New Zealand's strategic geographical location globally as someone who offers relatively rare and quite expensive Southern Hemisphere GBSI coverage. Now, there are two issues with this. Number one, we go back to the issue of the role of Te and the role of Māori within this space, and how that relationship will be rebuilt, will be made stronger despite the lack of consultation. I think that is something we have yet to see the Minister making a commitment on, and we would like to see further work being done in that space. The second area is around what is considered national interest. Now, I want to be very clear. The Green Party has always talked about the need for independent foreign affairs or foreign affairs policy here in Aotearoa, New Zealand. And we are concerned with the fact that we have seen Five Eyes expanding beyond what is an information sharing agency to potentially interfering with even something like this around GBSI, because it does say that the minister may seek advice from NZSIS, and as we know, NZSIS has a singular target and a singular country that they're targeting as a result of this. So in this case, is this national interest or is this Five Eyes interest? And I think we need to be very clear on that. So yes, the Green Party does support this, but I think there's a lot more work to be done around this area.
Tim van der Mulde.
Madam Speaker, now I want to pick up firstly on the blatantly untrue statement made by Ms Brooking before in her contribution that the previous government had not used urgency to pass any bills through all stages. That was verbatim what she said. And incredible, Madam Speaker, a short search shows 24 bills were passed through all stages under the last government, 17 of those outside the budget process, and indeed included changes to the electoral law of this country. Totally unjustified use of urgency. This case, Madam Speaker, is a particular case for a particular purpose that has been well traversed for sensitive issues, and so I commend the bill to the House.
Oh, excellent.
Madam Speaker.
The Honourable Priyanka Rahakrishnan.
Thank you, Madam Speaker. I just want to set the record straight, given that the member who just resumed his seat has claimed that the Honourable Rachel Brooking said that our government never passed any legislation under urgency. That's not what she said. What she said was that we didn't do it as much as this government is doing it, and we didn't do it for reasons that seem completely unjustified for significant bills, as this government has done repeatedly, time and again. However, she also acknowledged that this bill is not an example of that. So it would pay for the member who made those claims to actually listen in future. And that would go for members opposite who've been unnecessarily nasty during this debate, given that members on this side are actually supporting this bill. The purpose of this bill, of course, is to manage national security and other risks to New Zealand's national interests that are posed specifically by GBSI or ground-based space infrastructure, and it does that through the enactment of a regulatory regime. Madam Speaker, we all know from NZSIS threat assessments, the most recent one in 2024, that companies that are focused on technology and innovation are particularly vulnerable, and we're seeing that. We've seen that in recent years. They are particularly vulnerable to being used by foreign states to advance their own military and intelligence goals. And often this has happened in instances where we've then found out that initially those malicious activities or that malicious intent was not actually even realised by companies here in New Zealand. So entities have approached New Zealand organisations specifically to develop space infrastructure in New Zealand territory. They have claimed that the purpose of that infrastructure was for civilian research, but it was then later found out in each one of those cases that that was not true, that the infrastructure could have inadvertently, was designed to assist foreign military activity, and the affiliations between those foreign entities and the entities that approach New Zealand companies were deliberately hidden. So none of us disputes the need for this legislation, which is to plug the gap in our regulatory frameworks or regulations, legislation that we currently have. We know that a lot of the ways in which this was addressed to date has been through non-regulatory measures. We know that space is increasingly contested and competitive, that technologies change rapidly, and therefore legislative fixes are required to continue to ensure our national security, and that is why, Madam Speaker, Labour is supporting this bill. However, there were a few concerns that I raised, questions that I asked during the Committee of the Whole stage that we've had. I will also make the point that this is being considered under all stages urgency. We accept the Minister's point that this is being done for national security purposes, and we don't question that. That is fine. However, I want to emphasise the point that my colleagues have made, both the Honourable Rachel Brooking and Venushi Walters in their contributions at committee stage. Also the amendment by Rachel Brooking, which was for the government to include a post-enactment review clause that would allow, given that this legislation is being considered all stages under urgency, accept that, but there is a mitigating factor given so much of detail is in regulations, given that consultation has been minimal. The consultation document was put out to 21 operators that are known to the regulator. However, only 2 have substantively responded to that consultation. That was on the policy intent of the bill. The actual bill itself, as far as we're aware, has not been consulted on. And so the suggestion from this side was a review clause so that we can mitigate that potential loopholes created by the quick enactment of this bill and also mitigate the lack of consultation on this legislation. It is disappointing that the Minister has chosen not to take that any further, and I do want to put that on the record. The other point that I raised was the lack of requirement within the legislation, within the amendment bill, for the Minister of Space to consult with directly ministers relevant to intelligence and security and the security agencies. The Minister has clarified in the committee stage that there is a requirement for the regulator to consult with the security agencies, and I accept that. However, don't see it necessarily written into legislation. Finally, the point that I made in committee that I felt was not addressed adequately was the fact that this particular option, there were 4 options laid out. One option, option 3, that the government has decided to proceed with, and that's what has led to this bill. I get that it's a balance between the effectiveness of the design and the implementation regime versus it being cost effective. I take that point. However, I have questioned the lack of resource that has been put into ensuring the effectiveness of the implementation. The Minister has said it's basically a movable feast. However, I don't necessarily think that gives this side of the House a huge amount of comfort that it's being resourced enough to be effective and protect our national security in that sense. However, Madam Speaker, those are the main issues that we have traversed, and ultimately, though, on balance, given this is a bill that aims to protect our national security interests, I commend the bill to the House.
Tim Costley.
I quote Rachel Brooking. I'm asked, when was that in the last government? The last government didn't do this all stages urgency, full stop. That is the direct quote. Let's just get that right.
As it relates to this bill.
That's not what she said, Madam Speaker, and I don't think...
No, I'm saying to you...
Well, this relates to this bill because that was her direct quote from this reading on this bill, and that is what the debate has centred on. What I would like to centre it on...
Mr Costley, what I'm saying to you is that please relate your debate to this bill.
Yes, Madam Speaker, absolutely. This is a debate on this bill. My debating point is to counter 2 speakers in a row now who have stood up and said that that quote was never made. It is in the Hansard. It would be outrageous if we couldn't reference that. Madam Speaker, this bill is actually something that we started out yesterday evening agreeing on, that there is a need here for our national security to act. We've got a minister that is acting quickly. We should move on, and I commend this bill to the House.
Māngai o te whare.
Aku koshla tangari menua.
E te māngai kia tuatua au ki te tautoko I tēnei pere mo te Party Labour, ara te pere Outer Space and High Altitude Activities Amendment Bill. Madam Speaker, I just want to commend that side of the House for having the wisdom to quote this side of the House. Very smart. Hoi anōra, Madam Speaker, in committee stages I raised a few points and that have been reinforced throughout. You can just wait and listen, then you can quote me. You can quote me for some words of wisdom.
I assure the member that I am listening.
Madam Speaker, while we support this bill, some of the things that I raised during committee stage must remain pertinent. In a time where people are telling us that they need jobs, better healthcare and homes, I know that it can be tempting to support initiatives for their economic development. But we must make sure that this remains about national security, which in these trying times is actually at the forefront of a lot of people's minds who it may not have typically been. While reference to Te Tiriti o Waitangi has been badgered this morning, it actually is very relevant. And while I've said we have learnt lessons from the establishment of Rocket Lab, the relationship with Rongomai Wahine, and while of course it's pleasing to hear not only the educational support but the employment support that comes from such projects, we have to make sure that Te Tiriti is honoured and mana whenua are honoured. Because while we're talking about space, and like I said, that debate will continue about kaitiakitanga in space, we are talking about ground-based science infrastructure. And at the end of the day, whenua is forever and kaitiakitanga is forever. So these conversations must go beyond consultation. In committee stages, I also raised the fact that while there was consultation, it felt rushed. Even when consultation is done well, the relationship with landowners, iwi hapu, and mana whenua must not end with consultation. Otherwise, it's mere lip service and it's a mere tick box exercise. This relationship must go beyond that to include the monitoring and the review of this bill. Because while you, at the moment, you've got to get authorisation from the minister, and this bill empowers the minister to assess whether proposed activities meet national interest. That's quite a lot to put on an individual responsibility. So, hei whakakapi, Madam Speaker, like I said, Rocket Lab is doing some great stuff, but there are lessons to be learnt there about the involvement of mana whenua, because like I said, whenua is forever and kaitiakitanga is forever, and that relationship needs to be from the start and enduring. So, Madam Speaker, on behalf of the Labour Party, I commend this bill to the House.
Dr. Vanessa Wiening. Thank you, Madam Speaker. I rise in support of the Outer Space and High Altitude Activities Amendment Bill in its third reading. I'm the MP for Banks Peninsula, where we have Tāwhaki based. That's a wonderful partnership between the Crown and two of the local runanga. It's a real exemplar of how the Crown and Māori can work together. And given that it is a site of advanced air aviation and potential space industry, I commend this bill to the House.
Madam Speaker.
The Honourable Phil Twyford.
Madam Speaker, the concluding remarks really in this debate from me is that just to observe that this bill is filling a gap in our regulatory framework. I noted earlier in these debates that many other like-minded countries have modernised their regulatory framework to properly keep an eye on and
control the use of ground-based space infrastructure to protect national sovereignty and to protect their national interests, including other countries who have space programs. And so it's right that the regulatory framework that was largely developed from an economic development perspective to support the growth of New Zealand's space program is improved in this way. And notwithstanding all of the debate we've had over the last 24 hours on this bill, I think it is a no-brainer that we should be supporting it because it is putting in place a mechanism that will allow this and future governments to protect New Zealand's national interest. So I've actually enjoyed the debate. Notwithstanding the fact that urgency has meant that it's been pretty challenging to tease out some of the detail and complexity and collectively, I think, to get our heads around the detail of the bill, but I think it has been, there hasn't been too bad a discussion in spite of that. We remain on the Labor benches here disappointed that the government has not supported Rachel Brooking's amendment paper that would have added a post-enactment review, and we think that on a matter of this importance, with some granularity in terms of the processes and the systems in place that it puts in place, it would have been much better, given that it's been rushed through under urgency without any select committee scrutiny or expert or public submissions. It would have been the prudent thing to do to legislate that review. And this House is very familiar with the defects and the flaws of law that is too rushed. I've enjoyed the discussions that we've had around the national interest test and national security. I remain of the view that I think that this regulatory framework would benefit from the additional principles that support the application of the national interest test in relation to the launch of payloads from New Zealand. Those principles spell out a much more precise definition of things that would prohibit certain payloads being put up. And I think that when we consider the potential threats posed by ground-based space infrastructure, there are some parallels there, and I think that a much more precise definition of the national interest test would be good for New Zealand. In relation to, I thought one of the interesting things that came out of the debate from my perspective was the what I call the Waihopai principle, where actually ground-based space infrastructure managed by the GCSB, our Signals Intelligence Agency, over quite a long time in New Zealand, was found to have been conducting mass surveillance on New Zealand's friends and neighbouring countries with little to no public oversight or parliamentary scrutiny. And we should learn from that episode in our history. And in the modern era, when much more advanced technology, much smaller kit is available to a range of private sector operators, we should be vigilant that ground-based space infrastructure cannot be used for that purpose in New Zealand without proper scrutiny and oversight. And my hope is that this legislation will enable this and future governments to take that responsibility seriously. Finally, I remain intrigued by the possibility that some future government may regard the ground-based space infrastructure of some embassy in New Zealand to be conducting a regulated activity under this law, and therefore exercise some oversight and control over that. Foreign embassies here and all around the world routinely use ground-based space infrastructure for the purposes of intercepting communications and carrying out intelligence gathering activity and surveillance. That's no secret. And in general, governments tend to turn a blind eye to that sort of activity. But the intent and the substance of this bill really asks us to consider whether or not we would consider that sort of activity carried out in New Zealand for purposes that may or may not be consistent with our national interest should be properly regulated. I commend this bill to the House.
Madam Speaker. Thank you, Madam Speaker. I am pleased to rise and take this last and final call on the Outer Space and High Altitude Activities Amendment Bill. We fully support the bill. We are pleased to see a regulatory framework for ground-based space interests. I'm not the MP for Mahia, Madam Speaker, but I am a frequent visitor. I am just next door, and my colleague and good friend Katie Nimmin is the MP for that area. And so on behalf of both of us, I commend the bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The party vote is called for, Madam Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
Um, 34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā pōti e whakahē ana.
Members, the ayes are 117, the noes are 5. The question is agreed to.
Outer Space and High Altitude Activities Amendment Bill, third reading.
I call on Government Order of the Day number 5.
Budapest Convention and Related Matters Legislation Amendment Bill, second reading.
Madam Speaker.
Honourable Paul Goldsmith.
I present a legislative statement on the Budapest Convention and Related Matters Legislation Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website.
Madam Speaker, I move that the Budapest Convention and Related Matters Legislation Amendment Bill be now read a second time. Madam Speaker, this bill aligns New Zealand's laws with the requirements of the Council of Europe Convention on Cybercrime, also known as the Budapest Convention. The Budapest Convention is the first binding international treaty on cybercrime, and it aligns members' nationals' laws relating to computer-related offences, improves investigative techniques and streamlines evidence sharing. By acceding to this convention, we join almost 80 countries party to the convention who are committed to working together to tackle cybercrime. And this positions New Zealand to negotiate further agreements creating key infrastructure and underpins international criminal justice cooperation. Now, what does this mean for New Zealanders? Why do we care about all this? Well, obviously the government has a very clear target to reduce the number of victims of serious crime and to restore law and order more broadly. The broad area of fraud and cybercrime has been growing significantly over time, and the Ministry of Justice Public Perceptions reporting shows that 78% of New Zealanders are worried about this, as they should be. And over the past 3 months of 2024, for example, the National Cyber Security Centre reported New Zealanders lost $6.8 million worth to cybercrime, and 91% in 12 months. So it's a big issue, it's a real concern, and the purpose of this legislation is to enable us to be part of this Budapest Convention and to share more information more quickly, deal with evolving threats more quickly, and helps us to be part of a coordinated international response to the broad issue. So the bill was reported back from the House from the Justice Committee. I want to thank the committee for their careful consideration of the bill and submitters. I want to thank the submitters who took their time to share their views. from copyright infringements to computer-related fraud, the violations of network security to child exploitation material. This bill will help safeguard New Zealanders from cybercrime. Makes several important amendments. The bill amends the Search and Surveillance Act 2012 to introduce a new tool for law enforcement called a preservation direction, and a preservation direction enables law enforcement agencies to require a person and a company to hold a specific document to preserve it for a specified period, protecting vulnerable evidence such as digital records from being deleted or destroyed. So that's important. We've got new disclosure requirements. Further amendments to the Search and Surveillance Act to create an offence for everyone affected by a preservation direction to disclose that the direction exists. Where police have a warrant to undertake surveillance, it will be an offence for anyone who assists them to carry out that warrant to disclose its existence. That's obviously important for successfully achieving that. And then we're making amendment to the Mutual Assistance in Criminal Matters Act, 1992, which governs the assistance we give to other countries on criminal investigation. The bill enables police to apply for production orders and surveillance device warrants in response to a request for assistance from a foreign country, and that's how we share our information. Then we also, to safeguard human rights, all existing requirements in the Search and Surveillance Act and Mutual Assistance in Criminal Matters Act must be met before a production order or a surveillance device warrant can be issued for mutual assistance purposes. So that's a very important protections by allowing only a mutual assistance order or warrant to be issued by a High Court judge. Collectively, these amendments will enable New Zealand to accede to the Budapest Convention. Now, the Justice Committee recommended some important changes to strengthen the policy of the bill. 2 amendments to Clause 37, ensuring the judge considers the public interest in both avoiding prejudice to proceedings as well as investigation, and ensuring the seized thing is not sent out of New Zealand before the person concerned has the opportunity to challenge. And also recommended clarifying 10(1)(b) and (c) of the Telecommunications Interception Capability and Security Act 2013 do not require an internet service provider to obtain traffic data, that is information. Here we go. I seem to have identifying the nature of the telecommunication if the telecommunication is not the internet service provider's own product. So we welcome those amendments. In conclusion, this is an important part of our effort to meaningfully cooperate with other nations in our fight against cybercrime, and will ensure that our laws protect New Zealanders in the digital age. Will send a strong signal internationally of our commitment to combat cybercrime while upholding a rules-based international order that protects fundamental human rights. And on that basis, Madam Speaker, I commend this bill to the House.
The question is that the motion be agreed to.
Speaker?
The Honourable Dr. Duncan Webb.
Kia ora. Thank you, Madam Speaker. And here at... Oh, the Minister's approaching me across the... No, he's not. The Labour Party supports this bill. This is a convention which was acceded to, I understand, in the last Labour government. But I do want to point out that these cross-border matters raise some quite difficult questions. And when we get to committee stage, I do want to, interrogate the Minister on New Zealand's approach to this, because cybercrime in particular is borderless. And the Budapest Convention, the whole point of the Budapest Convention is to ensure that the response to cybercrime is borderless as well. And that means ensuring that telecommunications, which is, in one form or another, pretty much the vehicle for cybercrime, can essentially be searched and surveilled effectively. But we in New Zealand and in the common law world hold dear privacy and freedom from arbitrary search and seizure. So here in this bill, we need to make sure that the framework on this, around these telecommunications, is robust and consistent both with the Budapest Convention, but also with the things that we hold dear. And this, the main, I guess, innovation or new aspect in this legislation is, as the Minister said, the preservation direction. And that is the direction that a telecommunications provider essentially hold and preserve information that might have content. It could be an email or a text message, something of that nature, or it could simply be traffic data. There were telephone calls that went in this direction, or there were, encrypted messages between these two parties. Now, again, there needs to be more than just an interest. And I think it's important to recognise that not all countries have the same robustness in their criminal justice procedure as we do, and equally not all countries have the kind of scrutiny about what ought to be criminalised as we do. And there is always a risk when we are particularly when we're assisting foreign nations, that we are assisting them in doing things that we wouldn't accept in New Zealand. And so we have to be very careful when the authorities here, and the Attorney General has an important role in this legislation, when those authorities are given, we need to have more than just a weather eye, but we need to be vigilant that we are not being unwittingly used to further either political ends or to allow a foreign state to pursue a proceeding against something that might be a crime in a foreign nation, but it certainly isn't a crime in New Zealand, and shouldn't be something for which criminal sanction follows. So that's what I mean when I say these cross-border matters raise really significant issues. Because we do not want to be essentially assisting foreign states in oppressing others. And if we look at and the Minister mentioned the Mutual Assistance in Criminal Matters Act, but if we look at the parties to that, that is to say those foreign states who we are required to assist, that includes the Hong Kong Special Administrative Region. And we know that some of the things that are criminalised there are very much free speech here. So that's this kind of thing, and we certainly don't want to be having surveillance orders and preservation directions in respect of messages which are simply political activities in New Zealand. So we need to be very careful about that. And I think we also need to make sure that we're not subjecting people who are innocent parties to inappropriate surveillance. Now, they may be, and of course, one of the things that this Act does, because aspects of it are quite technical, is it shows the pathways of communications. People might want to know, for whatever reason, where messages are routed and who has passed those on. So those kind of things need to be examined as well. And the legislation creates a raft of new offences, which I think, again, any time an offence is created, they're generally offences about non-cooperation or destruction of material. We need to make sure that they have the right settings, that a criminal offence shouldn't exist unless there's particularly an appropriate mens rea element. And a lot of these offences are organisational offences, because if you're going to be seeking preservation directions from a telecommunications company, you've got to make sure the left hand knows what the right hand's doing. And if some junior member of the organisation deletes files in a routine way, that we've got to be cautious about imposing genuine criminal liability for that. So there's a whole lot of stuff in this legislation. But at the same time, the Budapest Convention is a convention which requires New Zealand to essentially take a cooperative attitude. And I must say, one of the challenges in cross-border enforcement is timeliness. And whilst the timeliness aspects in the domestic setting in this legislation, I think are pretty much okay, if you look at the length of time that orders can exist in respect of cross-border orders, it seems quite extraordinary. The length of time seems very long, and so information can be held in abeyance. And I guess the other thing that I'd point out and kind of preface what I intend to raise in the committee stage is the suggestion that there can be essentially secret seizures, that items can be seized, such as including communications, and sent to a foreign state, and the person who is affected doesn't know. Now, secret and justice are two words that don't usually go together. So I want to know, I will be wanting to know exactly what the kind of threshold is for us sending secret evidence to foreign states, especially when we think about some of those foreign states that will be asking for it and their own record. So there is actually a lot in this Act, and to the uninitiated, it's a very dry piece of legislation, but in fact it touches on freedom from arbitrary search and seizure, it touches on open justice, and it touches on criminal offending. So they're all actually pretty important matters. It might not be as kind of headlining as some of the criminal justice material that comes before this House, but it is important. And to be honest, the Minister did make a good point when he said, cybercrime, crime which often is scams, is often depriving people of their hard-earned money, is serious criminal offending. And it's very hard to detect. And we need to absolutely be pursuing those crimes because they cause real harm. And the victims, it can cause extreme financial distress to lose tens or even hundreds of thousands of dollars to scams and other cybercrime. And of course, hacking, the bill, the space bill we've just done, essentially underlying that is a hacking issue. The idea of blackmail by hacking is another massive issue. We need to be on top of that. It's a massive security risk as well as a commercial risk. So yes, we do support this bill, but I do think that particularly as it's being heard under urgency, a robust committee process will be important, and I look forward to that shortly.
Kaharani Carter.
Thank you, Madam Speaker. I take this call on behalf of the Green Party to speak to the Budapest Convention and related matters legislation amendment bill. The Green Party have reviewed this bill carefully and in good faith throughout the first reading and select committee stage. At the first reading, we supported it through to select committee, as this is the place which we sought to raise concerns with how this bill is currently drafted. It should be of the utmost importance to all MPs to make sure that our laws that we are creating are fit for purpose. Madam Speaker, I want to be clear that the Greens are committed to the underlying kaupapa behind this bill and acknowledge that the implementation of the Budapest Convention was a recommendation of the Royal Commission of Inquiry into those horrific March 15 attacks, where it was clear that our laws and our processes did not protect the people of Aotearoa. We are committed across this House to ensuring that those atrocious acts never happen again here in Aotearoa. Here in the FIAN's submission to the Royal Commission of Inquiry into the attack on the Christchurch mosques, I just want to start by showing the 51 names of the people who lost their lives in that attack in my hometown of Christchurch. And it is so important that we We listen to the people that were most affected by those attacks. We all recognise the responsibility that we as a legislator have in ensuring that our policy settings in Aotearoa are safe and protect all of us. The Budapest Convention and Related Matters Legislation Amendment Bill amends two key pieces of legislation, the Search and Surveillance Act 2012 and the Mutual Assistance in Criminal Matters Act 1992, to better equip our collective resistance against cybercrime, because cybercrime knows no bounds and no borders. Offenders can be located in one country, their victims in another, while the evidence is stored on a server in a third. The Budapest Convention, which this bill implements, provides a framework that allows countries to work together on criminal investigations. It covers critical cybercrimes such as the deployment of virus software, fraud, and the distribution of child exploitation material, and terrorism. With that responsibility, Madam Speaker, comes the responsibility to make sure that we are passing the best law possible that seeks to achieve the intent it says it will. At the first reading and throughout the Select Committee stage, we engaged constructively and worked across the House to raise concerns on some of the specific clauses and sections in this bill. However, Madam Speaker, as the bill has not subsequently addressed these concerns in its current form, we cannot, at the Greens, support this bill in good faith. I want to be very clear that if these concerns are addressed in the Committee of the Whole House stage, which is coming up just after lunch, and our amendment papers are agreed to, amendment papers that we have created through consultation with our trusted stakeholders like FIANZ, then we will passionately support this bill. We have a responsibility to ensure that Aotearoa is safe for all of us. Madam Speaker, the Greens remain concerned about the definition of an offence, specifically the use of terminology such as improper conduct, which remains unacceptably broad. This could leave interpretation open as to whether individuals or groups could be operating as part of a foreign power when engaging in non-violent protest or criticism of the state. The language used in this bill leaves open the possibility that an individual engaging in political protest in solidarity with an international movement could be swept into the scope of an offence. If we narrow this definition, it will make it much clearer that we will be sticking in line with the laws of Aotearoa, New Zealand. This bill does not make a distinction clear, the distinction clear, and the Greens are committed to passing legislation that is fit for purpose and achieves the intent of keeping communities safe. Now, while we support the intent of this bill, which was to strengthen international cooperation on cybercrime and protect victims, there are provisions that, as currently drafted, raise serious concerns and must be improved at the Committee of the Whole House stage, which I'm looking forward to getting into with my colleagues after the break. Specific concerns are Clause 88A, bracket 4, close bracket, which could allow surveillance of political refugees simply because their country of origin is a treaty partner. This risks undermining human rights obligations, something that we don't want to do in Aotearoa. Further, clauses like 88B, 88V and subpart 2 sections 20A and 43 lack clear human rights and proportionality safeguards. We can put these safeguards into our legislation, and that is what the Committee of the Whole House stage is there for. Without these, New Zealand might be required to assist in investigations into conduct that isn't even a crime here, or cooperate with countries that do not meet basic standards for a fair trial or privacy protections. Furthermore, Madam Speaker, the Greens remain concerned about the new offences introduced in Part 2 of the bill, particularly sections 253 and 254. This is work we will continue to push for and across the House at the Committee of the Whole House stage. Madam Speaker, I would also like to take this call to raise my disappointment in the consultation process of this bill. A big failing of this process was not hearing from FIANZ. I spoke with our trusted stakeholder and their representative Atif from FIANZ, the Federation of Islamic Associations New Zealand, who expressed their concern around the lack of consultation. And Madam Speaker, they have provided a quote here. Quote, despite being the community most directly impacted by the March 15 terrorist attacks, the national umbrella body, FIANZ, was not consulted. The Royal Commission of Inquiry clearly recommended that meaningful consultation with affected communities must be a core part of the government process. With the release of the New Zealand National Security Strategy, it is essential that such consultation becomes standard practice, ensuring that communities are not only informed but actively involved in shaping the politics that affect them. End quote. So, on one hand, we are bringing in one of the recommendations of the Royal Commission of Inquiry whilst ignoring another one, and we can do better than that. Madam Speaker, I urge the government to actively consult with FIANZ moving forward to ensure the best possible outcome for this bill. To conclude, Madam Speaker, the Green Party acknowledges the sobering context in which led to the introduction of this legislation. The Royal Commission of Inquiry into the March 15 terrorist attack made it clear that together we must strengthen our collective ability to prevent harm, particularly where online platforms are being used to spread extremist content and incite violence. We must protect our sovereignty and our core values as Kiwis. We need to be careful that we are not upholding laws from other countries that do not even fit with our own laws. Madam Speaker, while we cannot support this bill in its current form, we are working to put forward constructive amendments to address these concerns. We continue to do so in good faith and in the hope that with the support across the House, this legislation can be strengthened to achieve the outcome we all want, a safer Aotearoa for everyone.
Laura McClure.
Thank you, Madam Speaker. I rise in support of the Budapest Convention and related matters legislation amendment bill on behalf of the ACT Party. Firstly, I'd just like to acknowledge the previous speaker's acknowledgement and recognition of the victims of the mosque terrorist attack. Also from Christchurch, I feel that really deeply, as do all the members of Parliament here in New Zealand. And I acknowledge that this was also a recommendation of that report to ratify or to enact our agreement as part of the Budapest Convention. I was actually in the EU, was it last week? Gosh, I can't remember. A couple of weeks ago with my colleague James Meeker, who I believe sits on this committee, and I actually had some meetings with our counterparts around a lot of these kind of issues and where we could work together in order to make New Zealand and the world a safer place. I share some of the same opinions as the Honourable Duncan Webb around privacy and around foreign states and how they may manipulate this legislation in order to, harm individuals that are New Zealand citizens. And I do share those concerns, but I think on balance we need to think about some of those countries and what they're doing in the space of cybercrime and how that does in fact cause foreign interference here in New Zealand. And I think that in itself is one of the main reasons why we need to work together with other like-minded countries when it comes to these issues. We need to make sure that our sovereignty and our security is in fact protected. Being a tiny island nation at the bottom of the planet in a digital world, we need to make sure that we do have strong links and strong ties with other like-minded countries in order to tackle these really big issues. We don't want to be left behind. So I'm really keen to hear some of the points hashed out in the committee stage because, like I said, the ACT Party does always consider the sovereignty and security of our residents here in New Zealand, our citizens, and we do take that really seriously. But I do commend this bill to the House.
Andy Foster.
Speaker, it seems a very appropriate time given the two previous pieces of legislation which we've considered. This Budapest Convention is our ratification of an international treaty in effect, and that's essentially exactly what we were doing yesterday in ratifying the UAE trade agreement. So we are showing ourselves as a responsible partner. In that case, it was a one-to-one. In this case, it's a multilateral arrangement as a responsible part of the global community. The other piece of legislation, of course, which we just considered, was the one relating to outer space. Why is that relevant? That's an area which is changing very, very fast. So is the area of cybercrime. And so this is about us responding to a fast changing situation as well. We talked in those discussions about being a responsible global citizen. That's true here too. And what this legislation is all about, what the convention is all about, is encouraging and allowing for cooperation between what we've heard is over 40 nations to combat cybercrime, which is obviously something which we experience ourselves here directly. I mean, even this Parliament has been under attack in terms of cyber activity, and so we are well aware of that. The legislative statement, interestingly, says that the convention, that New Zealand's legislation, it ensures that New Zealand's legislation fully aligns with the requirements of the Council of Europe Convention, the Budapest Convention on cybercrime. But it's interesting that Madam Speaker, that the Justice Committee actually says that there are a number of areas where legislation in New Zealand needs to be tweaked to ensure that we do actually fully comply. So there's a slight discrepancy there in terms of the language which is being used. It's all about preservation of documents. So if a document is suspected as being something related to cybercrime, it requires that preservation that prevents disclosure of that. So there's some very useful initiatives which are being taken there. I did hear, Madam Speaker, the concern about some of the broad definitions, and I guess one of the things that I would say is asking questions of the Minister about whether this is the same language that other countries which are signatories of this to this convention are also using. Madam Speaker, I note also that there are a number of reservations that are proposed that we do not that would not apply to New Zealand. The reservation about the range of offences, so they are more severe offences, not more significant offences, rather than relatively minor ones. And the second reservation that would limit the ability to prosecute New Zealand's ability to prosecute New Zealanders who commit cybercrimes outside New Zealand to only those most serious and severe offences, such as terrorism and human trafficking. So, Madam Speaker, I look forward to the ongoing discussion about this, but this is about us being a responsible player in the global environment in the area of cybercrime. I commend this bill to the House.
Lawrence Zunan.
Thank you, Madam Speaker. I rise on behalf of the Green Party to speak on the Budapest Convention related matter legislation amendment bill. Now, as the previous speakers has already mentioned, this particular legislation does amend two key pieces of legislation, the Search and Surveillance Act 2012, the Mutual Assistance in Crimes Matters Act 1992, and also there are definitely elements of the Crimes Act in there as well. But I think more broadly, one of the things that has been addressed as well is this is something that is addressing an issue that we're currently seeing manifesting in a greater capacity due to the prevalence of online presence in general in our daily lives. But one of the things, and one of the other things that is also really important as a result of this legislation is that it does come on the back of the recommendation from the Royal Commission inquiry into March 15th attack. And I want to really acknowledge my colleague Kahurangi Carter and in her speech talking about the way that we have supported this in the first reading and has gone through the select committee in good faith in order to try and get an outcome that both addresses the concern but also doesn't diminish the rights of people here in Aotearoa, New Zealand. And unfortunately, during the select committee stage, we haven't really got to that stage. So the Green Party cannot support this bill in its current format in the second reading. But of course, if the Minister is open to conversations and discussions and amendments in the committee stage, we may revisit that. We may revisit our position in the third reading. Just in terms of the process itself, we have heard from a range of submissions around this particular bill during the select committee stages, but I think it would be it is important to again highlight the fact that while this bill was a recommendation of the Royal Commission inquiry into March 15th attack, one of the most affected communities as a result of that attack was not consulted as part of this. And we heard that loud and clear from the Federation of the Islamic Association of New Zealand, FIANZ, in their submission, which is disappointing because it is something that we're hoping would strengthen our domestic legislation and make our people safer. But there are certain parts of this bill that does fall short of that. I think the other really important thing as we're looking at it, again, from a Bill of Rights perspective, is the way that this legislation and ability for people to conduct search and seizure and also investigation does touch on a number of Bill of Rights concerns, specifically things like Clause 14, Clause 15, 17, and 21. So anything from freedom of expression, freedom of association, freedom of association in terms of religion, and also thoughts and thinking, and also the conditions around unreasonable search and seizure. And the reason that this bill touches on a lot of these particular areas and has drawn broader concerns from the Green Party is the ability that for us to investigate or even survey people here in Aotearoa who are captured, who are protected by our Bill of Rights on the basis that our treaty partners potentially would consider these people to be a threat without us, at least from a legislation perspective, going into the detail of whether those requests from our international treaty partners are in line with our domestic value and the value that we hold really close to our heart in Aotearoa, New Zealand. And I'm, particularly from the perspective of Bora, as I have mentioned. So there are specific concerns that we have seen, and I think the consistency report that we do see against Bora doesn't quite go far enough to unpack the severity of this. And finally, I want to say that one of the things we're also going to be looking into a lot more as a result during the committee stage is the amendment paper that the Minister has also released, which wasn't seen during the select committee stage. So we look forward to that in the committee stage as well.
Tom Rutherford. Oh, thank you very much, Mr. Speaker, and it gives me great pleasure to rise in support of the Budapest Convention and related matters, and to our friend from the Te Pāti Māori Party who's turned up to give a contribution, which is great. I just want to clarify for him that the New Zealand that this bill fully aligns with the requirements of the Council of Europe Convention on Cybercrime, hence why it's known, Mr. Speaker, as the Budapest Convention, which is quite useful and quite good to clarify for members across the House. I know others will have substantive contributions on the material involved with this legislation, but I commend it to the House. Oh, very good.
Mr. Speaker.
Honourable Jenny Anderson.
Oh, thank you very much, Mr. Speaker, for an opportunity to take a call on this bill. The Budapest Convention, Mr. Speaker, is designed to update New Zealand's legal framework to combat cybercrime more effectively. It paves the way for New Zealand to be able to join the Budapest Convention and it also enhances our international cooperation in this space. And can I just highlight how important it is, particularly in cybercrime, to have those international connections when we know that cybercrime criminals, those operating in this space, specifically work to exploit where there are gaps between countries and to exploit those gaps for their own financial and personal gain. So the more that we can join up and have a network of agreed rules and how we cooperate with each other, it reduces the opportunities for those cyber criminals to be able to carry out their work. This bill introduces new tools to be able to do that work, new tools for law enforcement, such as limited data preservation orders. Sounds long, but we'll talk about that later. Big fan of limited data preservation orders. This helps to secure digital evidence, really critical to trace who is doing the crime on the internet and also how we try and hold those individuals accountable. And that is an incredibly difficult thing to do in cybercrime. This also improves the mechanisms for accessing electronic data and cooperating with other countries on cybercrime investigations. And that's an important note to make. And I think it's important for anyone who's been a victim of cybercrime, who understands the different forms in which it can come in, whether it be phishing scams that we're all trained here on Parliament not to click on the links, ransomware attacks, identity thefts, financial fraud that's online, and also hacking into computers. We're all familiar with those, with how cybercrime operates. But it is interesting that in New Zealand, what I often hear in terms of electorate inquiries is that if someone has been a victim of identity theft or someone has been a victim of cybercrime, it does appear that the threshold for action, for law enforcement action, is a lot higher than it would be if that happened in real life. So if shoplifting, we know that under 500, under national is not investigated by police, but say it's over 500. So if it's over 500 and you get someone turning up to investigate that crime, whether it's been shoplifting or a burglary, that threshold for cybercrime does appear to be quite a bit higher. So when you have someone who's been a victim of a scam and they may have lost $10,000, they're often directed to simply go through their bank or go through other channels, as opposed to trying to actually have a proper investigation on that. So it doesn't seem right that we have different thresholds for the fact that things happen online as opposed to in real life, because what that does, Mr. Speaker, is that sends a green light to criminals who operate in this space, that if you're wanting to take people's money, then you're less able to be held accountable online than in real life. And so that is why having these agreements in place, but also backing up these agreements with the appropriate resource. So we have a specific unit that is able to investigate and hold criminals accountable for cybercrime, whether they are based in New Zealand or whether we are cooperating with our international counterparts to be able to share that information and hold people accountable. Because the tighter the net is around these areas, then it reduces the chances of people being scammed and losing their savings. And particularly for those who are new to using the internet, I think of people in my parents' demographic where they've clicked on links and had themselves exposed to ongoing text messages or ongoing scams to try and extract money. It can be really stressful for people retired who have got their fixed income, who have their retirement savings. They are targeted often through operations such as this. So what this bill does, in fact, Mr. Speaker, is it amends the Search and Surveillance Act, which was passed back in 2012, and also it amends the Mutual Assistance in Criminal Matters Bill. And the primary change to the Search and Surveillance Bill introduces preservation directions in support of domestic criminal investigations and also overseas criminal investigations and proceedings. It establishes an agreed network of cooperation to minimise the opportunities for criminals to use online tools to extract money and to extract threats from people. This bill enables the Commissioner of Police here in New Zealand to issue a preservation direction requiring documents, and that includes computer data, it's important to note, to be preserved where there are grounds to believe that documents are particularly vulnerable to loss or modification. A preservation direction is an interim measure, and that interim measure ensures that the evidence in the form of documents is preserved before a production order is sought requiring those documents to be produced. So it's essentially an evidence gathering tool that can be used to not only trace who is doing the offending, but also to hold them accountable and whereabouts they're operating from. And if those actions are taken earlier on, then it shuts down that operative from preying upon more and more individuals, whether they be here in New Zealand or in other countries across the world. This bill also requires a person who is subject to a preservation direction or assisting in executing a surveillance device warrant, such as, for example, a telecommunications provider, to keep the existence of the direction or warrant confidential for a period of time to avoid prejudice in a criminal investigation. And we know, Mr Speaker, from the Select Committee process and from hearing some excellent evidence and information provided from telecommunications providers, there was some concerns about how long they would have to hang on to large amounts of data. And so all of those issues we talk through in detail to be able to understand how we can make sure that the telecommunications providers are still able to operate effectively, but at the same time they are also doing their bit to enable that data capture can occur when required. As mentioned, this bill also amends the Mutual Assistance in Criminal Matters Act to enable production orders and surveillance device warrants to be applied for in support of international criminal investigations and proceedings. And this is about New Zealand doing its part, because we do know that those cyber criminals are operating in big-scale scams right across the world. So if we are participating alongside of other nation states, then that reduces those opportunities for them to take advantage of people and their savings. There are appropriate oversights to ensure that human rights are upheld, and this ensures that the full suite of investigatory tools are available in New Zealand. Where appropriate, to be able to support those international criminal investigations and proceedings. Labor supports this bill because we support the Budapest Convention in order to try and fight cybercrime. We believe that we have a clear role in taking up our part in a global fight to increase cybersecurity capabilities and international cooperation. This bill builds on Labor's previous efforts to join the Budapest Convention, and it also implements the recommendation from the Royal Commission of Inquiry into the Christchurch terror attack. It also has the benefit of modernising New Zealand's legal framework to effectively combat cybercrime. And that is important, Mr Speaker. It maintains a balance with privacy and human rights protections while also ensuring we increase our cooperation and ability to get on top of cybercrime. The legislation strengthens our law enforcement tools, improves international cooperation and demonstrates our dedication in Labor to have public safety in the digital age, so incredibly important. By joining the Budapest Convention, we aim to position New Zealand as a responsible global actor in addressing cyber threats. And we know, Mr Speaker, that this crime area is growing. This is an area where there's more crime happening, not not only do we need to make sure that we're signing up and participating, but also, Mr. Speaker, in making sure our law enforcement agencies here in New Zealand are adequately resourced so that we can take our part on the world stage to reduce cybercrime.
Thank you, Mr. Speaker, for the opportunity to speak to the Budapest Convention and Related Matters Legislation Amendment Bill. The Budapest Convention is the Council of Europe's Convention on Cybercrime. With cybercrime posing a serious and significant threat to the public, and because our international partners are mostly already signed up as parties to the convention, and because we take cybercrime seriously, we support the bill and the cross-border mutual cooperation to enforcement that it enables. I commend this bill to the House.
Ruben Davidson. Thank you, Mr. Speaker. I stand to take a call on the Budapest Convention and Related Matters Legislation Amendment Bill, which Labour continues to support. We signed up to the Budapest Convention, and so it's good to see that this important work continues. Now, a number of speakers have already discussed the borderless nature of cybercrime, and that's what can make it so difficult to detect and to prosecute offenders unless we have an appropriate level of international cooperation. And that's what the Budapest Convention sets out to achieve, so that when these offences are committed online, you can have an offender in one jurisdiction, the victim in another, and the evidence of the offence being held in a server in a third country or territory. So it can be very difficult with various countries' legislations to actually join all of that together to be able to track down and ultimately apprehend and prevent further cybercrime from happening. Now, cybercrime can take many forms, and I think it's worth taking a moment as we step through this legislation that we all agree on to look at a particular example of some fairly abhorrent cybercrime that has happened here in Aotearoa, New Zealand, where a Taranaki grandmother has lost close to $250,000 to an AI deepfake that featured Prime Minister Christopher Luxon. So an online manipulated video purporting to be a message from the Prime Minister, and as a result, this person has lost $250,000 online into cryptocurrency. So the way that this happened was that a video advertisement appeared. The person listened to the message, apparently from the Prime Minister, and started to engage with what they thought was an investment advisor online. Over a series of weeks, $20,000 each time was taken out of term deposits that were in fact the victim's inheritance. And a lot of the funds were also earmarked for the victim's grandchildren. So this was someone, no one can afford to lose $250,000, but this was someone who that was essentially their life savings. And over a series of days, the funds were drained and transferred, converted into cryptocurrency in a foreign account, and then bounced away and out of reach of the New Zealand-based victim. Now, potentially the worst part of this, because the scammer was able to access this person's online banking and watch and manipulate her actions. The last words that the scammer ever said on the phone while speaking to the victim was an aside to someone else in the scam centre they were operating from, and they simply said, "This woman has no money." This woman has no money. So that scammer had literally drained all of the funds out of that victim's account and only stopped when there wasn't a single dollar left for them to take. And that's why legislation like this is so important, to be able to track down people operating from other territories that do those kind of attacks. Now, there was an interesting comment, because the Prime Minister rightfully was questioned about this and said that he would never endorse a particular investment. and the best way for people to protect themselves was to be vigilant and aware of risks. And to a point, absolutely that's true, but also legislation like this helps to protect people and helps to provide international cooperation around enforcement. Now, on that note from the Prime Minister, that very sage advice from the Prime Minister where he says the best way for people to protect themselves is to be vigilant and aware of the risks. That comes with any scam. So if, for example, 21,000 people are promised that they will be eligible for Family Boost and only 153 people are actually delivered the funds that were promised, then that potentially could fall into a scam as well, and in my opinion should be a risk that all New Zealanders need to be aware of, whether it's a deep fake or a shallow fake. A promise that's not delivered and a promise that's broken is shameful, but I do commend this bill to the House.
Mr. Speaker, I'm glad we can all agree that rising cybercrime is of great concern for New Zealanders, and that's why we're here in the House today supporting the Budapest Convention and related matters legislation. And this legislation improves cross-border investigations and prosecutions related to cybercrime, all while upholding human rights and particularly the right to be free from unequal search and surveillance. It's all a part of our plan, Mr. Speaker, to restore law and order and restore real consequences for crime. I commend this bill to the House.
Walters. It's a pleasure to rise in support of this bill, but Mr. Speaker, as the House has gone a little bit quiet, I thought I'd speak about urgency for a little bit, because we are still in urgency. We are still in urgency, and I was just wanting to make a brief point and then extend, I was going to say extend a fig leaf, but no, extend a olive branch to the other side, because I do think the issue of urgency is an important one for the House to think about when we use it. I did obtain some research from the Parliamentary Library on the hours that the House has been in urgency this term compared to last term. So in the 53rd Parliament, the House was in urgency for 15.7 of those total hours. For this Parliament, up until the 9th of May, the House was in urgency for 22.6% of the total hours. So there absolutely has been an increase in terms of hours. But I also do think, particularly for my National Party colleagues, that it's a disservice to the people of New Zealand when we point fingers at each other both ways, because in truth, there is a sense that urgency is being used more often than it should be, and there is an opportunity as the Standing Orders Committee consider the standing orders to think about the parameters under which urgency should be used. You will not find an objection in terms of my Labour Party colleagues and I that there are good reasons for using urgency. The question is simply, when should it be used and how should legislation be reviewed that has gone through the House under urgency? And I did speak earlier about other countries who've adopted various measures, including post-legislative scrutiny, including sunset clauses as well. So I do hope that members opposite will take that on board as we head into a period of reviewing the standing orders. Mr. Speaker, I do rise in support of this bill. As my colleagues have pointed to across the House, cybercrime is absolutely an issue for New Zealand, and it's an increasing issue. The Ministry of Justice's Crime and Victims Survey 2019 showed that over 320,000 people experienced one or more incidents of fraud or cybercrime in the 12 months preceding the survey. But as my colleague Ginny Anderson also pointed out, there is an issue in terms of policing this and monitoring it and ensuring that people get a response. So I do think this legislation is important, but I also do think we need to think about how we give it effect. Interestingly, Mr. Speaker, this isn't the only international convention in existence in relation to cybercrime. There is this the Budapest Convention, there is also a draft UN Cybercrime Convention. And I think in the international space, sometimes there's confusion between the two. I wanted to briefly just set out the differences between the UN draft convention and the Budapest Convention, because I think it points clearly to why New Zealand is using the Budapest Convention as the model under which we're developing legislation. So the UN Convention, firstly, is broader in scope. So it goes far beyond what would be considered cyber-dependent crimes. The UN Convention also creates new offences that aren't in the Budapest Convention, so it's far broader. It has also expanded jurisdiction, and what was interesting when the UN Convention was being negotiated is there were countries like Russia and China who wanted to include what are called content offences. So this is where you might find freedom of speech significantly limited, and that was absolutely the intention, to reach into quite a different space in terms of monitoring what potentially their citizens were saying overseas, as well as others. The UN Convention also has fewer human rights safeguards, and that alongside these extensive criminal definitions, I think, is problematic. And certainly a lack of safeguards in terms of procedural requirements that members have spoken about today in terms of the person who's accused. So while I do think that the Budapest Convention is a better model under which, for us to develop legislation, we do also still need to be careful that we're managing the fine balance of preventing global cybercrime while also protecting the rule of law and certainly rights against unlawful search and seizure. So I did want to speak to a couple of aspects in this regard. So firstly, in relation to the requirement that requires a person subject to a preservation direction to keep the existence of the order confidential, so keeping this confidential from the individual who's accused, if you like. Not only do we have the protections in legislation, I think often in the House we forget that we also have principles of common law that apply in this case. So the duty of candour is essential in our law, and essentially it provides that where there are adversarial proceedings, ordinarily you will have a right of response if you're accused of something. But for obvious reasons, when it comes to a search warrant or it comes to situations like this, you may not want to, for obvious reasons. The information may be destroyed, so you may not be able to provide that information to the individual. The duty of candour, in my view, still applies. So you would still have a circumstance where the application for a preservation order would need to consider any potential objections that could be made before it's granted. And while I couldn't find case law precisely on this point, there is case law in terms of search and seizure, or certainly search, where the individual isn't notified before a search is conducted. And the case of Nikki Hager versus the Attorney General is looked to fairly frequently in this regard. So it says that that obligation must be satisfied. You have to look at how the individual might object. The other issue is, of course, what happens when information is seized and then sent out of the country, and this is an issue that the Select Committee raised in terms of amending Clause 37. So the bill now includes a requirement that people affected by a search are notified before seized material is sent out of the country. This is essentially so they can potentially bring a judicial review claim should they wish to prevent that information going out of the country. Interestingly, this was a point that also came out of case law in the AG versus .com case. Now, the reason this is important is something that my colleague, the Honourable Dr Duncan Webb pointed to, which is that there is misuse, or there's potential to be misuse in terms of requiring information is sent overseas. Part of the misuse is due to a lack of dual criminality, so if there are criminal offences that exist in a foreign country that simply don't exist in New Zealand. And sadly, Mr Speaker, around the world we're seeing more what's called transnational repression. So this is governments who are actively looking to target often their own citizens and prevent them from speaking out against human rights violations. And certainly the likes of Amnesty International and Human Rights Watch have commented on this very frequently. So we need to be extremely cautious that we're not aiding that in terms of potentially extraditing individuals, or even without extraditing them, putting them in harm's way because they have family members in a home country, and evidence would be supplied by New Zealand to show that they were a dissident in some way that was considered illegal in their home country. Certainly there are many examples of that happening, even in terms of foreign nationals who are in the US. There were some fairly famous cases in the early 2000s of attempted kidnappings of Iranian nationals who were human rights activists. Now, of course, we haven't seen that happen here, but what's interesting is that before those kidnappings happened, there were other measures that those governments took to try and stifle their free speech. So, Mr Speaker, I am supportive of this bill, but I do think it's a very careful line that we have to walk. It's a piece of legislation that I do hope that we will rigorously examine in terms of committee stage, which I look forward to doing. Kia ora.
Just before I take the next call, what I will do is I'll take the National Party call, then I will come to the Department Māori call.
Thank you, Mr Speaker. It's a pleasure to rise in support of the Budapest Amendment Bill. This is a sensible piece of legislation. We've well discussed it through the House today. Many really excellent points about the requirement to make online activity a lot safer and to tighten things up, and I commend the bill to the House.
Maria Meno Kapakingi.
Speaker, tēnā tātou te whare. Exactly like my colleague on the right, I would repeat comments made this morning that unless the House recognises, appreciates and completely embeds in any of our debates in this House and into legislation te tiriti o Waitangi, unless that occurs in a genuine and real way, we're screwed. So here we go. And Madam Speaker, just to say, it is obviously easier to go from a no to a yes, so I'm going to. We can't support this because it doesn't quite have enough in it from our point of view and from our experience to support it going forward. Any international treaty on security must come with firm assurances. This is especially important when our own government refuses to uphold Te Tiriti o Waitangi, our founding document. So when we discuss cybersecurity, our security more broadly, we need to understand it through more than the Western lens or the comfortable and privileged lens. What security means to Māori may look very different, and it absolutely does. For us as Māori, security must include direction for Te Tiriti o Waitangi, particularly in the protection of Māori data sovereignty. And within the context of this bill, security must also protect us from government overreach that disproportionately harms our communities. Very recent history, let me recall it, when security powers are misused, the government sanctioned raids on Tūhoe, where false accusations of conspiracy led to deeply harmful and unjust operation on one of the most recent large-scale examples of this behaviour. That poorly managed government-sanctioned response costs lives. We cannot afford to open that door to that kind of behaviour again. Yet, we need only fast forward to the absolute tragedy of the Christchurch mosque attacks. Where was the security for this community? A deeper look into the prevention failures from government revealed that resources had been misallocated, driven by bias and prejudice against our Muslim communities. Once again, lives were lost. This bill risks continuing that pattern by expanding surveillance and international data sharing powers without explicit safeguards for Māori rights. That speaks directly to the issue of Māori data sovereignty. Our data and our information should be just that, ours. What this treaty risks is the ability for our people to exercise mana motuhake over our data. This is critical to success of Māori self-determination for whānau, for hapu and iwi Māori businesses. Unlocking economic and social potential is enabled by Māori data collection and analysis. Māori must own Māori data, Māori future, Māori mokopuna, Māori whenua. We do recognise here, Madam Speaker, that there are some upsides to this bill, but like I started off, it's easier to go from a no to a yes than a yes to a no. We're still in the no lane. We acknowledge that the kōrero of other members of the House have provided, but our role here has been and will always be to advocate for mokopuna Māori, for whānau Māori. Nō reira I rungi tēnā, Madam Speaker, just to, I guess, again, remind us that unless the House fully recognises to the left and to my left and to my right that Titi o Waitangi is and for always will be our founding document, and just to encourage the House, please read some more. That would be really helpful. I think just filling that gap of knowledge, like my colleague on my right said very early in one of his first stands in this House, there's such a huge gap of knowledge. So I'd encourage you, please read some more. Kia ora tātou.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Budapest Convention and Related Matters Legislation Amendment Bill, second reading.
This bill is set down for committee stage immediately. I declare the House in committee for consideration of the Budapest Convention and Related Matters Legislation Amendment Bill.
Members, the House is in committee on the Budapest Convention and Related Matters Legislation Amendment Bill. We come first to the debate on Part 1. Part 1, this is the debate on clauses 3 to 53, amendments relating to investigatory tools and schedules 1 and 2. The question is that Part 1 stand part.
Kia ora, Mr.
Honourable Dr. Duncan Webb.
Chair, thank you, Mr. Chair. Just to preface the remarks, because obviously this is a bill of, pretty technical and pretty detailed, and sometimes I think we kind of can fail to see the forest for the trees, fail to see the water for the stormy seas, as they say. And I do want to firstly say, yes, we absolutely support this bill, but I want to note the overarching concerns, which are twofold. One is to identify that this is an exercise of state power against citizens, and I just want to say that we want to make clear and put on the record exactly where that balance is struck. And the second part or theme that my comments and questions will identify is the difficult tension in the New Zealand state in exercising its powers against citizens, assisting foreign states, and particularly in assisting foreign states. I'm going to be frank about that, repressive foreign states who don't have the same human rights values as we do. So from that, I'm not going to dilly-dally. I'm going to get straight into it and invite the Minister. A lot of what I'm going to do is essentially to invite the Minister to expand and explain to the public, for the record, what it's all about. At the centre of this, one of the keystones of this legislation are preservation directions, and so this, whilst we've already got production orders that say telecommunication providers can be ordered to, go and find and present the particular information, this preliminary step is seen as important to make sure that whilst those production orders are being sorted out, no one goes around hitting the delete button, in short. And I guess, so the first thing I want to ask it's on page 14 of the bill as reported back. And I'll just, I'll talk about the new sections. New section 79A talks about enforcement agencies. And I do think it's quite important to understand what that means in terms of who has these powers. In terms of the mutual assistance provisions, it appears to be the police. And we're interested in the Minister's comments on whether enforcement agencies simply means the police and obviously things like Crown Law when they're taking advice and so on, or whether it will extend to other enforcement agencies, like a classic one would be customs, or in fact whether it could go broader than that, because certainly if we were to say prosecuting agencies, there's a plethora of prosecuting agencies in New Zealand. So that's my first kind of question. That's actually a question of clarification. Then my second question is kind of an invitation to explain, because the very next definition talks about pathway information. So because we know telecommunications data can be routed through numerous servers and so on, and I'm asking this genuinely because I don't quite understand it. Why is pathway information important in a criminal investigation? I can understand why sender and recipient information is important, but I'd be curious to understand why we need to know that it was routed through, or routed, if you say it that way, this server or that server, and so on and so forth. Particularly if we know that the telecommunications provider holds the relevant data, they have the text message or whatever it might be. And I'm going to just keep cracking on because this is a bill we agree with, and I'm not going to hold things up, so I'm going to squeeze another question in as well. And it's around section 79B, which is that the enforcement officer may apply for preservation direction. And it's about the threshold because it says the enforcement officer can apply for it if that officer is satisfied that the conditions in section 79E for making a direction against that person are met. And I guess all of whenever you're exercising search and surveillance powers, it's all about suspicions and about the reasonableness of those suspicions, reasonable grounds to suspect, reasonable grounds to believe, and those kinds of thresholds. You don't often see a kind of very subjective test that the enforcement officer is satisfied. So, I've managed to squeeze in kind of three queries in there, and I'll do a bit more later.
Thank you, Mr. Speaker. Just looking here at part 3 of the legislation, subpart 1, interpretation, bracket S, 88A, close bracket, and that's actually on page 28 of the bill as it stands. And I want to explore the rationale and ask the Minister to explain the reason for using certain definitions in the clause 88A bracket 4 close bracket, particularly regarding...
Can you just give us that page number again?
Sure, it's on page 28, thank you, and it's, part 3, subpart 1, S88A. This definition is regarding the offences of political character, and I'm wanting to explore and would love the Minister to engage with my question around why the standard political offence safeguard appears to be narrower than in comparable legislation. Is there a reason for that? I think it's really important that when we are looking at bringing in a law that potentially opens us up to laws that don't belong to New Zealand, that belong to other countries, but through this convention we would have to uphold because of certain treaties we have with other countries. And I think that us as a country and the everyday people out there really want to know that we're not doing anything that goes against our national identity, and ensure that our citizens are not being asked to uphold laws that don't belong to us and that do not represent who we are as New Zealanders and our country of Aotearoa. And I guess that takes me into the next part, just in the same subsection in part 3. Can the Minister clarify whether the term serious offence in this part is subject to any threshold test? We really want to make sure that any proportionality or dual criminality under New Zealand law is actually met. So looking at whether that serious offence has been tested against what we in New Zealand deem as a criminal offence in New Zealand, and just really going back to that core concern that we have heard from trusted stakeholders like FIANZ around and I'm asking the Minister if you could please explain whether there are any safeguards in place to ensure that preservation directions are not guaranteed in relation to offences that would not be recognised as criminal in New Zealand. We just really want to make sure that New Zealand, we are a place where we're living by our laws and not importing laws that don't belong to us and aren't fit for purpose here in Aotearoa. And just one more question on this part 3, subpart 1, S88A. Can the Minister explain the basis for clause 88A, bracket 4, close bracket, bracket B, close bracket, and how bilateral agreements are assessed to ensure they are consistent with New Zealand's human rights obligations? We have our New Zealand Bill of Rights Act, which we commonly call BORA, and we have our Auditor General who audits and measures the things that we do here as a government, our government actions and our legislation to uphold our laws and our citizens' human rights. So we just want to make sure that that is being done here in this law. So if the Minister can explain how the bilateral agreements are assessed to ensure that they are consistent with New Zealand's human rights obligations.
Maria Meno Kapakini. I did see your lips move, but the microphone.
Sorry, thank you. I hope that's not always the case. Morena. Minister Morena, my questions in relation to this bill are centred on Māori data sovereignty. You might have picked that up in my speech. Keen to just question why the Minister has not considered including provisions that would safeguard our people. Māori have the right to control their own data. That might be a clue in there. Crown agencies could or should consult with Māori, including area authorities or relevant stakeholders. There should be an establishment of a Māori advisory panel to monitor how preservation directions and data sharing are used where Māori and Māori data is involved. there should also be, if I might mention this before my question, which is coming, a cultural impact statement when sharing evidence internationally that involves Māori individuals, organisations, iwi authorities and culturally sensitive information. This will protect against the misuse of Māori data, particularly in international contexts where tikanga Māori is not understood. So, Minister, Clause 4, Section 3(1), which is the amended definition of surveillance power. This clause updates the definitions in the Act to include new terms like surveillance power, traffic data and relevant agencies involved in intelligence and enforcement, which is an oxymoron sometimes in this country, just saying. Can the Minister confirm why in Part 1, Section 3, Subclause 1, the definition of surveillance power does not include criteria that would safeguard Māori from disproportionate levels of surveillance or discrimination, especially in the context of the Tūhoi raids, which only happened a little while ago? Speaking to the same section, Minister, I note there is no reference to Māori data considerations in the definition of traffic data as it has been drawn from Section 3AB of the Telecommunications Act 2013. However, I would question whether the Minister considers inserting provisions here to state and define Māori data or culturally sensitive data so that it better protect Māori interests. If he does not agree, I would ask the Minister to explain the reasons for that. This is us trying to get from the no lane to the yes lane, Minister. Kia ora.
No lane.
Minister Waters.
Thank you, Mr. Chair. And like my colleague, Dr. Duncan Webb, I just have some questions in relation to the restraint of power, because obviously these are considerable powers in terms of search and seizure, and certainly the preservation of documents, which to my mind triggers privacy issues, and just looking at clauses to see whether they've been drawn down or reasonably limited to ensure that we are walking that line. So I'm looking at page 12, and it is, see, section 10, which inserts the new clause 64A. This one is about the destruction of information that is found as part of that surveillance warrant process, and it says that a person must ensure that as soon as reasonably practicable after the warrant expires, that record is destroyed or given to law enforcement agencies. So the first question is around whether there was consideration that that language should be restricted, as it's very hard to determine what reasonably practical may be in relation to. The second is in relation to clause 12. And clause 12(2)(I), which says if the documents are sought to be produced on an ongoing basis, the facts relied on to show how reasonable grounds to believe that these documents are in the possession or under the control of the person against whom the order is sought. So, two questions. The first is, if this is referring to documents that are produced on an ongoing basis, was there consideration of slicing that up to ask for a production order for each of those documents as opposed to the set of documents? And the second is about the definition of under the control of the person against whom the order is sought, or will come into that person's possession or under their control. Again, there's no restriction in terms of timing there, so it stretches out to a document that will at some stage come into their possession or under their control. All of that language is extremely broad. A question about whether there was consideration of bringing that down as well. In terms of page 14, subpart 2A, this is the start of the preservation directions section. I was first wondering about comparability of definitions across borders with countries of like jurisdiction who we would be communicating with, and whether the preservation order provisions are the same. That's the general question. The specific question is an issue raised by the Privacy Commissioner, which is the fact that the Commissioner of Police is able to issue those preservation orders, and the Privacy Commissioner considered that quite unusual. The proposal from the Commissioner was that that's the type of order that ought to require judicial oversight, and certainly that would be the more responsible thing to do given the nature of the power. Someone's having information collected and held about them without knowing that that's the case. So whether there was consideration of just drawing that down and how that compares internationally. Thank you.
Danica Patrick.
Mr Chair, I move that the committee report progress.
Leave a thought for that purpose. Is there any objection? There is an objection. Dr. Lawrence Unan.
Also, just a point of order.
Hold a second, I'm just going to clarify. Could you repeat your contribution again?
I move that the committee report progress.
Yeah, the question is that the motion is agreed to. All those that put that opinion will say aye. Aye. To the contrary, no. The ayes have it. The party vote is the party vote being called for? Yes. The party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā pōti kore i whakai.
The ayes 102, the noes are 20. The question is agreed to. I will report progress on the bill.
Yes.
Yeah.
The House is resumed.
Madam Speaker, the committee has considered the Budapest Convention and related matters legislation amendment bill and reports that it has made progress on the bill.
The question, I'm going to report.
Madam Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. This bill is set down for further consideration in committee next sitting day. Danica Patrick.
I'm just not sure of the. I'm not sure of the protocol, but I'm informed that the House intends to lift urgency.
So the government has indicated that urgency will conclude. Therefore, the House stands adjourned until 2 p.m. today.